15 years cold. The Rashaun Jones case. We're breaking down one of South Florida's most talked about cold cases, the 2006 murder of University of Miami football star Bryan Pata. Pata was a 22-year-old defensive lineman from Little Haiti, one of 9 kids and a rising NFL prospect. On November 7, 2006, just hours after practice, he was shot execution style in the head outside of his apartment.
At what address? 9315, Southwest 77th Avenue.
What happened there?
Somebody got shot. The guy's on the ground. I don't know where he's bleeding from, but he's on the ground, man.
Okay, and if you just stay with me on the line, did you see what happened?
No, I did not see what happened. Nobody see what happened, man.
His wallet was full of cash and was still on his person. This looked personal. No robbery, no clear suspect. Then, ESPN's investigative reporting in 2020 helped blow the case back open. They dug through thousands of documents, sued for records access, and located witnesses. Less than a year later, in August of 2021, former teammate Rashaun Jones was arrested and charged with second-degree murder. Jones has always maintained his innocence.
And what is your position? What are you thinking?
Deep down in my heart, I know I'm innocent. So that means I got to go to trial to prove my innocence.
Well, that's up to you.
Jones's first trial earlier this year ended in a mistrial after the jury deadlocked. Reportedly, 5-1 for acquittal. Now, we're heading into a retrial in September, but the case has only gotten messier. We're talking about a circumstantial evidence case with some messy layers. A controversial jailhouse witness who's popped up as a witness in other cases before. Questions about disgraced former prosecutor Michael von Zamft and how he handled that informant. And now most recently, the lead detective is facing an internal affairs investigation over alleged biased comments on social media using burner accounts during the first trial. The state of Florida's theory is that all roads led to Jones. Motive, the timing, an eyewitness, phone records. But the defense says that after 15 years with no new evidence, this looks more like the state is just responding to pressure from the family, and that it's the product of tunnel vision. So in this series, we've got old footage, we've got trial testimony, the current motions fight over what the jury is allowed to hear, and the twists that are going to keep coming in as we approach the new trial, which we'll cover that too. We're going to lay it all out with a live stream format, with a live chat to interact and figure it out together. So here we go. Drop your thoughts in the chat or the comment section if you are on Replay Crew, and let's get into it. Welcome back for our second session on the Florida versus Rashaun Jones case. In session 1, we went over what happened before this even became a case, before Rashaun Jones was arrested, and we started looking at some of his pretrial hearings and some interesting testimony. So if you caught that already, let me know what you're thinking we might see as we go through all of the docket leading up to the February 26th trial. And if you missed it, you could go check it out after this if you want to hang out with us live. I think you'll still be able to pick up on what we're doing. And it's going to be a time. It's going to be a time. This docket has 894 entries. It's a lot. It's a lot of entries. A lot deal with depositions in Florida with criminal cases. One of the things Florida is very open to is having defendants in a criminal case, giving them the ability to call witnesses and depose them before it gets to the trial stage, which I think is really cool that we have. It also creates a lot of extra docket entries. Let's get the chat on the screen, though. We're going to be working from the bottom up. We're going to be going to the earliest entries, working our way up towards the February 2026 trial. And once we get to that ending, our next session is going to be watching that trial in full. So everybody buckle up. It's going to be a lot to get through, but we're going to do it. And you see all of this stuff in the beginning. Right when someone's arrested, of course, you get, all of the intake, you get arraignment, and, you see things like demand for a trial by jury, plea of not guilty, and you start getting motions for discovery, attorneys making their entry of appearances. And in the beginning, we had public defender for Rashaun Jones. He ends up having a bunch of attorneys come in. He gets some attorneys that come in to do pro bono work after hearing what his case was like. And let's see, let's get to the first motion of substance. All of this stuff, this is taking us through about a year already, or about half a year. And now we're about at the year mark. We're 2 years in. So August of 2023, it's been 2 years since his arrest at this point. At February, we start to have documents available. Lots of depositions or notice of depositions, subpoenas being sent out. And all the way up here, we start to have this notice of appearance, Sarah Alvarez. She's going to be who we see do opening arguments at the trial. So she's going to be someone you'll get used to knowing. She didn't enter this case until February of 2025. So just think about like over 2 years have gone by before the main attorney that we're going to see has entered the case. We also have a Jason Wander come in. And everybody's okay with them substituting the counsel. And then we get this document. And I mentioned it in session 1. I think you guys are going to think it's interesting. Here we go. So this is motion to compel discovery and demand for Brady material. This is April 8th, 2025. It's just shy of a year before trial. And we're going to see a ton of stuff that has not been turned over to the defense, even though he's been in custody since August of 2021. So we've got the defendant, Rashaun Jones, buy-in through undersigned counsel. Moves this court to compel the state to comply with its discovery obligations. And in support of this motion, the defendant states as follows. So quick background, August 19th, 2021, which is almost 15 years after the victim in this case was killed, Bryan Pata. Mr. Jones was arrested for first-degree murder, and he was later charged with murder in the second degree. So chat, if you have some thoughts on that, let me know what you think. We'll make sure you guys have a tall reaction box for this stream. What do you think about that? Charged with first-degree murder for the arrest, but by the time we do the information, the indictment, we're going to go with second degree, not first degree. And remember, the theory was somebody was lying in wait in the apartment building bushes or behind the dumpster waiting for Bryan Pata to come home from football practice. That was the theory. But now we're going to downgrade. We're going to do a little downgrading. So then we've got, since the day of his arrest, Mr. Jones has remained incarcerated pending his trial. On September 1st of 2021, Mr. Jones invoked reciprocal discovery in open court and or filed a notice of discovery. So here we are. April 2025. He asked for discovery. September 1st, 2021. On February 8th, 2025, undersigned counsel, this is Sarah, entered a notice of appearance. Shortly thereafter, undersigned obtained the discovery from prior counsel and confirmed receipt of all items turned over by the state pursuant to the initial and amended discovery exhibits, apart from the items listed below. So she cross-referenced everything. And this long list we're going to see below is everything that's not there. Undersigned counsel's review of the detective supplemental records revealed the existence of significant missing discovery, including Brady material, that has never been disclosed by the state. Undersigned counsel has repeatedly requested the outstanding discovery, both in person and via email. The state has responded with either vague answers or no response at all. To date, the defense has not received any of the discovery requested, included but not limiting to the following materials. So addresses. So how do we get in contact? How do we send subpoenas to witnesses? So we've got Jada Brody. We've heard that name. Some of these are going to be familiar, but a lot are new names to me. Sherry Abramson, Patricia Morgan, Jessica Flowers, Dwayne Hendricks. So Dwayne is the roommate that lived with Bryan Pata when he was killed at the Colony Apartments. He's the one that did the 911 call. Mike Sanders, Stephen Caldwell, Kareem Brown, Dave Howell, who we watched him testify, Bruce Johnson, Eric Monker, the dorm room owner, Willie Williams. He was at the club with Bryan and also was roommates with Eric Monker. We have Hamlet Castillo. We have Sean Shanatzi, Kahani Andrew Lyons, and Jorge Molina, who's the former Miami-Dade Police Department sketch artist. We're also looking for written statements. Seems like basic Brady material stuff here. Written statements including summaries or notes taken by law enforcement or prosecutors, and or audio-video recordings of all interviews of the defendant, Rashaun Jones. Any written statements including summaries or notes taken by law enforcement or prosecutors, or audio-video of all interviews with all witnesses, including listed or not listed, including but not limiting to Paul Connor, that's going to be an important name, Jada Brody, Lucinda Brody, Susan Brody, Allison Thomas, Sherry Abramson, Patricia Morgan, Jessica Flowers, Dwayne Hendricks, Mike Sanders, Stephen Caldwell, Kareem Brown, David Howell, Bruce Johnson, Eric Monker, Willie Williams, Christopher Barney, Chris Zellner, Darnell Jenkins, Richard Gordon, Christopher Rutledge, Devin Hester, Greg Olson, Randy Shannon, Larry Coker, Evan Shine, Edwin Pata, Edric Pierre Pata, Fednal Pierre Pata. So we've heard from Edwin and Fednal. Renette Pierre Pata, Jeanette Pata, Junior Pierre, Nellie Pierre, Gina Dennis, David Selmer, Jerry Brown, Hamlet Castillo, Sean Shinazzi, Kahani Andrew Lyons, Mike Foster, Russell Douglas, Jeremiah Gillings. They want anything and anything from any of these individuals. Louis Castell, Sonia Constante, Maiko Veloy, Jose Hernandez, Juan Carlos Martinez, Anno Clark, Gregory Jean-Baptiste. We got more. Adam Wayne Ross, Bernard Brinson, who's an inmate that said some other guy named Emanuel Jones, who's also on this list, confessed to him, and then Bernard Brinson took a polygraph and passed it, but they couldn't pan this out. They said he was somewhere else at the time of the murder. And then George Jones. These Jones do not have relations to Rashaun Jones. They are not related. George French Jones is going to be the key jailhouse snitch that we're going to see in a lot of these motions. What else don't we have turned over? Is this looking good so far? Are we doing a good job with discovery? Do you rate on a scale of 0 to 10? Is the state doing a good job turning over what they should be turning over? We've got, where are the written statements, audio, video recordings, and/or police reports pertaining to Paul Connor's session with the Miami-Dade police sketch artist Jorge Molina. We're also looking for all discovery pertaining to the Crimestopper tips received by law enforcement, including but not limited to any written statements, including summaries or notes taken by law enforcement or prosecutors, audio, video recordings, and/or police reports pertaining to Crimestoppers tip number 6. Submitted by Detective Jose Lopez of South Miami Police Department on November 10th, 2006, advising of a shooting incident that occurred shortly before and was possibly related to Bryan Pata's murder. So, 3 days after Bryan Pata is shot at the Colony Apartments, somebody calls in and leaves a tip and says, I heard a shooting like right before that. It could be related. So they want the information on this tip. And it seems like they heard about it through Detective Hatz's supplemental report. They want all discovery pertaining to the investigation of Michael Coco, aka Coco with an A, Pierre, an alleged gang member involved in a fight with Bryan Pata at Club Life and possible suspect, including but not limited to any written statements, including summaries or notes, audio, video recordings, police reports, and criminal history. All discovery pertaining to the investigation into Emanuel Jones. So the state's saying Emanuel Jones, even though Brinson said that Emanuel Jones confessed to this thing, to him, and he passes his polygraph. But we checked it out and it couldn't have been him. Well, they haven't turned over the discovery of what that investigation, how they found out that that checked out and couldn't be. They haven't turned over to the defense the information on that. So this is the inmate who confessed to Bryan Pata's murder, according to another inmate, including but not limited to written statements. They want audio, video, police reports, criminal history, and any jail calls. All discovery pertaining to the investigation into Wilner Yacinte. I think that's how you pronounce it. I don't know. A Haitian national who confessed to Bryan Pata's murder, according to ICE agent Marable's confidential informant, including but not limited to correspondence between ICE and the state and/or police department, written statements, including summaries or notes taken by law enforcement or prosecutors, audio, video recordings, police reports, criminal history, and jail calls. Now, session 1, the very last thing that we watched was like when the trial was supposed to start in February of 2026. There was this bombshell, and it was about this. It was about this disclosure, something related to another piece of information relating to this. It seemed like, from what we heard in those reports, from the reporters that came outside the courtroom when this happened, that the defense, the ICE agent ended up getting in contact with the defense. But here we are reading something that was filed in 2025 asking for discovery about this information. So was there something that could have been turned over to the defense that bombshell moment wouldn't have had to have happened the day that trial was supposed to start? Then they're asking for recordings of news or media broadcasts regarding Bryan Pata's murder. And this would be, they could go and get this on their own, but if the state has already collected certain things that they, especially if they plan to use it, bring it on in. They see that stuff was referenced specifically in Detective Hatz's supplemental report. So whatever you're referencing here for your report, we want you to turn that over to us. We've got a subpoena for Bryan Pata's University of Miami student judicial file and all materials produced in response to the subpoena. And they see that that's referenced somewhere. So again, a lot of these things that they're requesting are things that are referenced. They're not just, we're asking just in case you have it. We're asking specifically because you've indicated or made a reference to or have relied on these specific things. And yet you have not turned it over to us. Then we've got all discovery and or subpoenas for MySpace. Because again, this happened in 2006 in connection with this case, as well as all materials produced in response to the subpoenas, including but not limited to the subpoena for the MySpace account associated with a comment posted on Bryan Pata's MySpace page shortly after he was killed that said, "I know who killed Bryan, that FIU N-word, I seen it with my own eyes." And again, that's referenced in Detective Hatz's supplemental report. And they don't turn it over. They don't turn over any information. Or maybe they didn't look further into it. Maybe they like screenshotted the comment. I would love to see this report. Maybe we will. But like, did they actually subpoena it? And if they subpoenaed it, why didn't they turn over the responsive documents? And if they didn't subpoena it, why not? But yes, we are talking about MySpace here. We are talking about MySpace. They want all subpoenas for credit reports of Bryan Pata and Jada Brody and all materials produced in response to the subpoenas. They want all subpoenas for cell phone records, including but not limited to the subpoenas issued for 9 cell phone numbers and all materials produced in response to subpoenas. They want the criminal history records of all civilian state witnesses. And they say that, look, pursuant to Brady v. Maryland, you're supposed to disclose stuff that is favorable to the defendant and material to either guilt or punishment. Then they cite here, you know, they've got Brady, they've got Giglio or Giglio, however you want to say it. They got Bagley and they've got Hurst, which is a Florida-specific case. They say this obligation to disclose favorable evidence extends to both exculpatory and impeachment evidence. So if you have criminal history information on witnesses, you need to turn that over. Even if that criminal history doesn't directly relate to my client's innocence or guilt, because it could be impeachment material, you have a duty to disclose it to us for any of the witnesses that you have on your list. We've got exculpatory material includes evidence that tends to negate the guilt of the accused in any way. Impeachment material encompasses any evidence that tends to discredit a witness and cast doubt on the weight of their testimony. The Brady rule encompasses evidence, quote, known only to police investigators and not to the prosecutor. Thus, to comply with Brady, the individual prosecutor has a duty to learn of any favorable evidence known to other actors acting on the government's behalf, including the police. So that's why you're not supposed to say, you know, the prosecutor, I wasn't aware, I didn't have possession of this just because the detectives did, just because the investigators did. So, not good enough. And then in the instant case, Mr. Jones is entitled to the requested materials pursuant to the rules of discovery, the constitutions of the United States and the state of Florida, and the state's delay has hindered the defendant's efforts to timely prepare for trial. So they request all of that stuff. And frankly, I think that was a lot to be requesting for someone who's already been in custody for 3.5 years. And we are also on docket item number 255 by the time this request comes in. So I think that's a minus for the state there. And then we go back to, we have motion to compel for this, probably the discovery, a lot of deposition notices. Yep, and there you see the order granting motion to compel discovery. So the judge says, state whatever you have, you're supposed to turn it over. Let's see. And the order was amended. So let's see if anything good's in here. All right, so order is adjudged. The defendant's motion is granted, and the state is to provide the defense with the following discovery or a statement that it does not exist within 30 days. So the subpoena for Bryan Pata is University of Miami. Well, let's just see, is this long? Let's see if they got the Crimestoppers tip. They got Michael Coco. They got Emanuel Jones. They got the like ice thing with Wilner. Media recordings. All the civilian stuff, the MySpace. Yeah, so it looks like nothing was excluded from this. And that's all just coordinating the hearings there. Okay, so that was, the order was there. Doesn't mean that it gets turned over, but maybe we'll find out. Oh, I wasn't sharing that. Sorry. It wasn't anything interesting. It was just a repeat of the list. And then we've got the order declaring the defendant indigent so they can get costs covered by the court. Let's see. Oh, here we go. I think this is a good one. So this is motion to suppress out-of-court and in-court identifications. So what are they asking for with this one? We've got the defendant Rashaun Jones, by and through undersigned counsel, pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution, hereby ask this court to suppress all out-of-court identifications of Mr. Jones made by Paul Connor, and to preclude any in-court identification. In support, Mr. Jones states as follows. This is a big issue. This is a major issue in this trial. So accordingly, this is going to be a long motion, and this issue is going to continue to be an issue further throughout the docket. So we've got, this case hinges on the eyewitness identification of Paul Connor. Why is that? There is no physical evidence tying Rashaun Jones to this crime, to the shooting. Nothing. No DNA, no weapon left behind, no physical evidence. So if we've got an eyewitness, that's like the greatest thing that we've got. That's the top of the chain of our priority of evidence here. So Mr. Paul Connor, he admits he did not witness the crime itself. So whoever he witnesses, he doesn't actually see in the moments doing the thing. Whoever he thinks he saw could have just been somewhere nearby moments after. So in the general vicinity. But this is an apartment complex. And I believe it was around like 7 p.m. at night. So not really an hour where things are quieted down. Nobody's coming and going. So he says he admits he did not witness the crime itself, and he concedes that the only link between the crime and the person he saw is their mere proximity to the scene around the time that Mr. Connor heard a pop noise. Beyond its questionable relevance, Mr. Connor's identification has been reshaped through repetition and eroded over time. This identification is not the result of his independent recollection of the person he saw on November 7th, 2006. The 2000s are getting me. Maybe there's let's see. This full screen option typically doesn't work on the whatever viewer MIAMI-DADE uses. Maybe we can let's see. Zoom in slightly using this. How's this? Yeah, we can get the whole thing that way. That's kind of better. All right, so they say it's this outcome of suggestive procedures. So they're saying that there's problems here. Suggestive procedures employed over the course of almost 2 decades that violate both constitutional principles and Florida's eyewitness identification statute. Accordingly, even if Mr. Connor's identification is deemed relevant, despite the lack of nexus between his identification and the crime itself, this identification lacks sufficient reliability to be admissible under constitutional and statutory law. Thus, all out-of-court identifications by Mr. Connor must be suppressed and any in-court identifications precluded. So the background here. In November of 2006, the time that this happened, Paul Connor was a 62, I think that means white male. I was like, woman, man, white male. Was a 62-year-old professor at the University of Miami who lived at the Colony apartment complex, the same apartment complex where Bryan Pata resided at the time. On the morning of November 8th, 2006, the day after Bryan Pata was killed, Mr. Connor saw a news broadcast about the shooting and contacted law enforcement to provide information he believed might be relevant. He claimed that at approximately 7 p.m. the night before, while walking home, he heard a pop, took a few steps, and saw a young black male jogging or trotting away from the apartment complex. And this is coming from Detective Dominguez's report. April 30th, 2016. He must have just been like redocumenting something. And then it says, but see Segovia report from November 30th, 2021, describing the individuals walking towards him at a brisk pace. Mr. Connor later conceded that the only reason he believed this person might be connected to the shooting was because of the temporal proximity between hearing the sound and seeing the individual, not because of any suspicious conduct or actual connection to the crime. And they cite Mr. Connor's deposition from 2023. While Mr. Connor testified that he saw the individual for just 2 or 3 seconds from approximately 2 to 3 feet away, he claims that this momentary glimpse allowed him to fully observe the individual from head to toe. And this is him, I guess, testifying at the Arthur hearing in 2022. Mr. Connor's description was vague. Black male, approximately 6 foot tall, 6'1", in height, with a slender build, close-cut hairstyle, and neatly trimmed beard line. And again, this is coming from that 2016 report from Dominguez. But at the Arthur hearing, he stated that he did not notice any facial hair on the person he saw. Are we doing good? Are we doing well? So it continues. So he didn't see facial hair. He had a neatly trimmed beard line. Then he didn't notice any facial hair. And then in his deposition in 2024, he then stated that the person he saw had a slight beard at the bottom of his chin that was not really that prominent. Mr. Connor spontaneously added that when the man smiled at him, he observed white teeth with no gold or silver dental features. Mr. Connor further advised that the person he saw was wearing a black t-shirt and dark blue or black shorts. But see Composite witness interview form from 2007, noting Mr. Connor's clothing description to include black shirt with jacket. Mr. Connor stated that the black individual was wearing a hoodie in a different statement. Oh my god, this is reminding me so much of the Edric Foss case. Oh my gosh, this is Florida. This is Florida, you guys. This is Florida. Mr. Connor, thank you for becoming a member. Miranda, good to see you. Good to see you. Friend from over at Take It to Trials channel. Good to have you here. Hope you're doing well. Thank you for becoming green. As you're coming in here, let us know what you think about these very consistent descriptions. And I understand things change over time, but this is something that you're calling in because you see a news report. You didn't go outside when police were there. You didn't call it in when you thought you heard a pop. You called it in because you saw it on the news, and then you worked backwards to try to jog your memory from at least overnight. And then, sure, if you're doing your best to try to recall these things in subsequent interviews or testimony, and you're just trying your best, whatever. I'm not saying he has malicious intentions trying to testify. But, at best, eyewitness testimony, eyewitness identification is inherently unreliable. It needs to be consistent. It needs to have something that you can corroborate. Like, the idea that you're going from a t-shirt to a jacket to a hoodie, that's a big change. Because if you think you're reporting someone, they might have been doing something suspicious, don't you think it would, like, be more notable if they were hooded up or something? So, I don't know. I feel like investigators, they just don't scrutinize this stuff. They're happy to have a witness. They're happy to get them to sit with the sketch artist. And then they're going to take that sketch and they could just say, this guy looks kind of like that person. And we get into the same trap that seems to happen in a lot of cases where the sketch can become whoever you want it to be. So we've got, let's see. Mr. Connor acknowledged that it was already dark at the time of his observation, which would probably make sense. November in Florida at 7 p.m. Initially, he informed police and later reiterated under direct examination by the state and Mr. Jones' Arthur hearing, which is like the bond hearing, that the area is well lit. Okay, well, that's helpful. While Mr. Connor initially testified that the area was illuminated by streetlights and a shopping center across the street, upon being shown photographs of the actual area in question, Mr. Connor ultimately conceded that 77th Avenue had minimal or no streetlights and confirmed that no shopping center existed across the street. Oh no. Oh man. Well, despite reports of a chaotic scene, and we have a footnote, so let's read the footnote. Oh boy. We've got Jada Brody, Mr. Pata's girlfriend, was in their apartment on the second floor of the complex, near the area where Mr. Pata was shot. According to Miss Brody, she heard Mr. Pata pull into the parking spot and began arguing with somebody when she came downstairs, saw his body on the ground, and called the police. Dwayne Hendricks, their roommate, drove into the parking lot moments later, found Miss Brody in a hysterical state, and assisted in speaking to the 911 operator. The audio I heard that ESPN provided, and maybe we can play that before when we finish this motion, maybe we can run and play that if you guys want. At least the way they presented it, they didn't indicate that they edited it or trimmed it down. It rings and it's Dwayne Hendricks speaking right away. I don't hear a woman's voice at all. I don't hear someone trying to speak and then handing the phone to somebody else to speak. So, but apparently he says Dwayne Hendricks drove into the parking lot, found Miss Brody in hysterical state, and assisted in speaking to the 911 operator, but that it was she called the police. Fire rescue and law enforcement arrived on the scene shortly after, followed closely by Mr. Pata's family and friends. And then oh wait, that's another footnote. All right, so let's go back up to where this was. This is a lot, man, and I really don't doubt that, like, most people in this case probably mean well, but it's just the nature of something being so old. 15 years old. So, let's see. Where was that? Okay. Despite reports of a chaotic scene, Mr. Connor stated that he did not see or hear anything out of the ordinary as he walked through the parking lot to his apartment unit and did not notice the victim on the ground or anyone else in the area at the time. So he just called in the next day. He heard a pop and nothing else. On November 9th, 2006, Mr. Connor met with forensic sketch artist Jorge Molina and assisted in the creation of a composite sketch portrait. And this isn't linked, but is it attached? Let's go down. Let's go down and look at that. We are on page 3. Sweet. So we don't have to rely on the one they show at trial. What the heck? Okay, hold on. Hold on. It was hard to see what they were showing on at trial, right? I was like working with like a sideways angle. It was from an angle. We've got to pull this up. We've got to pull up, like, let's see if we can find an older picture. Okay, well, this one he has his mouth open, so it's not really the best comparison. All the quick Google searches are giving him from the trial when he's older. Oh, maybe this? Hold on, let me open this. Okay, so... Oh, actually, you know what? Let me save. StreamYard just finally enabled in the year of 2026 resizable overlays. So I should be able to pull this up and then move it side by side. They didn't used to let you do that. So let's put this up. Let me load this in. Let's put it on the screen at the same time. I used to have to go to like Canva or any type of imaging thing, make the image, and then load whatever I wanted into StreamYard. Files. Must be PNG. What did it save as? All right, let me just redo it. And then what we can do like letter grades, like A, B, C, D, E, F on how close this is. Or if you would think it's the same person. If it wants to load. Okay. How do we grade this? How do we grade this? I don't see it. I don't see it. And this photo, it says University of Miami Hurricanes football player Rashaun Jones is shown in this 2006 handout photo provided by the school. So it's the same year. It's the same year. I don't know, this sketch kind of looks like a different ethnicity to me. But we did it. We did a group exercise here. We did a group exercise. I don't think anyone's going for it. So again, the guy that did this sketch called the day after when he saw a news story. Said he saw a guy in a shirt or a jacket or a hoodie jogging. It was well lit from the street lights and the strip mall across the street from the angle that he was looking at. And there's no strip mall, there's no street lights. So yeah, one obvious similarity. And that seems to be a problem. And there are studies, you know, like if one race is trying to describe or identify another, it's just more difficult. It's just more unreliable when you're trying to identify and describe what somebody from another race looked like when it comes to forensic sketch composite drawings. So, yeah. So we were here, and was there something, let's see, let me pull this off so we can see. Was there more below it? Was there something else related? Oh, the witness interview. Wait, it kind of just looks like this. They started from this and just like colored and added some hair. All right, let's zoom in on this and see what we can see. Oh man. All right, so this was, it looks like 4:30 p.m. It looks like maybe. Hopefully not a.m. November 9th, 2006. They describe as male, black, early 20s, mid 20s for the age. Complexion, does it say medium smooth? What does that say? Medium. I don't think the second word is smooth, but I don't know what it actually says. But it looks like it says medium something. Hair color, eye color, H for hazel? Or, oh, hair is left blank. What is, 6:dark. Height is 6 to 6'1". Build is slender, good shape, athletic. And then I think this is the grading. So this is how they describe and grade. So hairline was neatly trimmed, no mustache, neck wasn't overly thick. They said he didn't have a thick neck. Oh man. Head is, I don't know what this means. Head is 1 through 11. I don't know what this type of notating would mean. I would need the sketch artist to explain why they notate it this way. Maybe it's like positioning. But there's an asterisk next to the eyes. Whatever they put here. They say the eyebrows are average, nose is average, mouth is average, chin, as for description, cheeks are high slightly, ears, as per description, hair was neatly trimmed, facial hair, beard neatly trimmed around jaw. So we have the difference in statement. So here we're seeing that he says it's neatly trimmed specifically around the jaw. But then later in a different, I think his deposition, he said it was just a little bit of a beard under his chin. On his not overly thick neck. Oh, Lord. What a time. Okay, and then this is where we do a identification. So this must be the 6-person lineup. I wish this wasn't... Can I rotate this in this window? Take a quick screenshot and I'll rotate it. Lineup. And is that the only one, actually? Or are there more below it? Oh, I have too many pictures in here now? Well, dang. Alright, we'll delete that one. Oh, I don't think it lets me rotate. Well, StreamYard still has room for improvement, so I can't rotate that. So we've just got it sideways. Everybody's got to turn their heads. Let's see. I mean, I'm so bad with faces that if one of these is supposed to be Rashaun, I wouldn't know that one of them is him. So I would not be good at this. And I just looked at a picture of him too. And then, all right, so they have notes here. Shown to Paul Connor on 6/6, or is that his date of birth? I think that's Paul Connor's date of birth, white male, and then it's his date of birth. And then they showed this to him on June 24th of 2007 at 10:55 a.m. So that's like months later. Why are they doing this on June of 2007? We've got more notes. Paul Connor, June 24th, 07. And he says he's 90% sure of his ID. I'm so sussed out that they're doing this in June of the following year. 90% sure as to number 2. Is this supposed to be number 2? Which way does 2 go? Like down or up? This one? Because he's writing under it, so that's why I think it's this one. And then lineup shown to Paul Connor on Wednesday, September 16th, 2020. Okay, so they're showing him the same set of images at a different time when he's already identified one. I don't think that that's a reliable way to do it. So that's where we're at. That's where we're at with those so far. It was really cool of them to include the exhibits. So yeah, they took this to trial. I don't know. Have a good one, Surf Girl. Thanks for hanging with us. I'm absolutely terrible with faces. I think I'm better with voices than I am with faces. Horrible with faces. Okay, picture of number 2. Give me a second to rotate picture number 2. This one. Is this just a random one then? I don't know. I think it'd have to be this one. Okay. Where is... Let me rotate it quick. Oh my god, it's so blurred. It's like so pixely. Download. Okay. I think it got worse. I think it's worse comparing it to this than his football picture. This does not look like the same person to me. I think this one had a better shot. Alright, so Martina M thinks this one looks like the defendant. Oh, or nope. Never mind. Never mind, I think Martina says nope. Is this the guy who walks to Walmart through Deer Park? Yeah, nose, lips, hairline are off. No. I think the only thing that makes it closer is just this photo. He doesn't have longer hair. So, that's a lot of teeth because he did describe the teeth, like saying that he saw the teeth. Did the guy walk by and say, "Hey, how's it going? I just shot somebody." And smiled at him. Oh, man. Well, let's see. Okay, we were like page... Yeah, here we are. So we were here. Let's zoom back in. Thank you, chat. That was fun. That was cool to like get the real time. We did some rotating. We put the photos next to each other and we got to see what you guys thought. We've got... They show this. We just looked at Exhibit B. He sat with the sketch artist on November 9th, 2006. And then on June 24th, 2007, about 7 months after the incident, Detective Dominguez responded to Mr. Connor's apartment and presented him with 2 simultaneous photo lineups that this detective created by comparing the composite sketch to images of persons of interest. Oh, I don't think you're supposed to do that. And including the photos he believed to most resemble the sketch. We've got a footnote. In the first lineup, Detective Dominguez included a photo of Alexandru Hinson, a person of interest, whose vehicle was reportedly in the area on the date of the shooting and appeared suspicious according to a resident of the Colony Apartments who took down the license plate and advised the police. All right, so they note that in this Dominguez deposition that they were just talking about from 2022, and it's also carried forward into the Segovia deposition from 2024. So they are noting that. The reason they're probably notating that is so they can demonstrate that, look, we had a tip and this is how we eliminated it because this person didn't identify this person. And again, it would only be them identifying someone that happened to be walking by, purportedly not suspiciously. And I'm not sure if that's enough to necessarily eliminate somebody because you don't know for a fact that that person walking by had any nexus to the crime. But it seems like they're documenting it to say that's why we stopped even considering Hinson was the guy. So then we've got, let's see. Detective Segovia was present for the identification procedure as well. Okay, so Segovia has been present for a while, even though he doesn't become lead on this case until 2020. But he was present for this 2007 identification procedure. After Mr. Connor failed to select an image from the first lineup, the detectives immediately presented him with a second lineup, which included a photo of Rashaun Jones for the first time. Mr. Connor selected Mr. Jones' photo, but qualified his selection by indicating that he was 90% sure, and noting that this guy doesn't have a thin beard, a physical discrepancy between the original description provided and the photo of Mr. Jones included in the lineup. The photo lineup procedure was not recorded or documented contemporaneously in any manner. Additionally, prior to conducting the lineup, Mr. Connor received no written or verbal instructions regarding the identification process. That's Connor saying so during his own deposition. He stated that the detectives did not provide any instructions like, he may or may not be there. Critically, detectives failed to inquire about Mr. Connor's vision or any medical conditions potentially affecting his ability to accurately perceive the events. Consequently, they were unaware that Mr. Connor was both nearsighted and farsighted, requiring prescription glasses for reading and distance vision, as well as legally mandated corrective lenses for driving. Furthermore, detectives were uninformed that Mr. Connor, who suffers from type 2 diabetes, experienced vision loss, double vision, and memory impairments associated with low blood sugar episodes. At some time in 2017, over a decade after the incident, exact date unclear since event not documented in any way. Oh man. Detectives traveled to Mr. Connor's residence in Toledo, Ohio to reestablish contact with him and review his prior identification testimony and statements to the police. Oh man. So they're citing here Paul Connor's deposition from 2022. It seems like that's how they're hearing that these guys took a trip out to visit Paul Connor. And Paul Connor remembers it being in 2017. Instead of presenting Mr. Connor with a new, procedurally sound lineup, that's why we're seeing the duplicates in the exhibits. Oh, man. The detectives informally showed Mr. Connor the composite sketch and presented him the very same lineup used in 2007. You're not supposed to do that because it's not supposed to be in the same position. Like, you're supposed to switch the photos. You're supposed to mix them all up. It's like shuffling a deck of cards at least. You want to at least shuffle them around. They left it in the exact same position. So they go and show him the same photo of Mr. Jones in the same position, as well as Mr. Connor's written notes and signature. They left his notes on it? Hey, can you tell us which one you previously identified? Is it like the same picture in the same place with your notes under it? Like, what are we doing? What are we doing? Oh, I just clicked to scroll. All right, we didn't move that far. I was like right here. Okay. No instructions were given prior to administering this lineup. Well, it was easy. They probably thought he didn't need instructions. It was all pointed out for him. It's right here, like the flashing lights, all pointing in the direction we need you to look at. And no updated confidence statement was taken. You're always supposed to take a confidence statement. Like the first one, you think it's 90% him. But I guess they didn't need it if his previous 90% note was there. So this interaction was not documented in any police report or recorded in any way. This is a lot. This is a lot. On September 15th, 2020, about 13 years after the incident, Detective Segovia and Detective Sable traveled to Toledo, Ohio to meet with Mr. Connor again. All right, so this is probably after the ESPN stuff. Like ESPN was starting to publish stuff on this already. The following day, they responded to Mr. Connor's residence to re-interview him, show him the composite sketch, and present him with the photo lineup once again. Mr. Connor advised that 13 years later, he remembered the entire incident the night of the murder and further stated that he was surprised no arrests had been made yet. Mr. Connor went on to tell detectives that he was walking southbound on 77th Avenue toward the Colony apartment complex when he heard what he thought was a cherry bomb, and immediately saw a black male in his young 20s, athletic build, emerge from the parking lot onto the same sidewalk that he was walking on and begin walking towards him in what he described as a brisk pace. When the detectives asked him whether he recalled the lineup that he identified, Mr. Connor said he remembered it vividly and reiterated that he was surprised to learn that we had not made an arrest on the case. Detective Segovia then produced the very same lineup, we're doing it for a third time, that was originally shown to Mr. Connor in 2007 and again in 2017, attached as Exhibit E. So that's why we had the three different, it was like kind of slightly different in the shading, the three different versions. Oh, Lord. And there's also a major elephant in the room here, right? This guy was a professor at the same university where these players were. Not only were they on campus, but I think a lot of professors could pay attention to the collegiate sports. So maybe you recognize somebody's face in that array of photos because that person's face is all over the scorecards and like the updates, and maybe you saw this picture when he did something. Maybe you saw this circulating around. Like, there's reasons you might be able to pick out his picture and think that person looks familiar to you that have nothing to do with you actually observing somebody in this parking lot. But that's where we are. And this is how it goes. This is how it goes. So he describes this brisk pace. When the detectives asked whether he recalled the lineup that he identified, Mr. Connor said he remembered it vividly and reiterated that he was surprised to learn. Oh, wait, I'm lower down. After looking at the lineup for a few seconds, Mr. Connor said, "The middle one on the top row, I remember it was him." At Mr. Jones' Arthur hearing on February 28th, 2022, Mr. Connor conceded that he couldn't help but remember the location of Mr. Jones' photo in the original lineup, which he had seen multiple times at this point. So they cross him on this. It seems like the defense gets up there and like, did you remember that his picture just happened to be in that exact same place? And he finally said, yeah. And when he was presented with the exact same lineup again in 2020. In conducting this identification procedure, no blind or independent administrator was used, no standard witness instructions were given, and no updated confidence statement was obtained. Once again, the identification procedure was not audio or video recorded. When Detective Segovia was later asked in deposition about the procedural changes with respect to conducting photo lineups, he acknowledged these changes and then stated his opinion as follows. I disagree with it. I think it was unnecessary, and I think it was a lot of hoopla by the defense. This whole thing with misidentifications, I go with the flow, and I don't see anything wrong or anything less from the way we did lineups and the way we do them now. If someone recognizes someone, they do or they don't. So that was from Segovia's deposition in November of 2024. Segovia's Mr. Burner account, allegedly. The guy on the social media with like balance justice _ whatever. On August 13th, 2021, almost 15 years after the incident and 4 days before an arrest warrant for Mr. Jones was obtained, detectives traveled to Toledo, Ohio, once again to facilitate a video conference between Mr. Connor and Assistant State Attorneys Michael von Zamft and Khalil Madani. According to Detective Sable, the purpose of the video conference was to discuss Mr. Connor's eyewitness account and availability for testimony. And they say here they wanted to go over the nature of the conversation we had with Mr. Connor. They wanted to go over the information that was provided to them. They wanted to go over his eyewitness statement. Probably knew he was getting old. Detective Sable was unable to recall whether the lineup was presented again during this meeting. This interaction was not detailed in any police report or recorded in any way. On August 19th, 2021, almost 5 years after Bryan Pata's murder, Mr. Jones was arrested in the above captioned case. On February 28th, 2022, over 15 and a half years after Bryan Pata's murder, Mr. Connor testified at Mr. Jones' Arthur hearing. We have a footnote. According to Mr. Connor, the night before his testimony, ASA, Assistant State Attorney Madani, took him on a walkthrough of the Colony apartment complex in preparation for the hearing. And that's Connor saying so in a June 2023 deposition. This is wonderful. During defense cross-examination, Mr. Connor was asked about his vision and medical history for the very first time. Footnote says Detective Dominguez confirmed that he never asked Mr. Connor about his vision or inquired into any medical conditions that could impact his ability to accurately observe or recall events. In response, Mr. Connor testified that he began to experience vision loss when he was diagnosed with type 2 diabetes back in 2002. By November of 2006, 4 years later, Mr. Connor testified that his vision was 20/40 without glasses, worse in the dark, and that he was legally required to wear prescription glasses for distance while driving. Understandably, when asked over 15 years later, Mr. Connor could not specifically recall whether he was wearing his glasses on his walk home from the metro station. However, he testified that he was accustomed to wearing these glasses only while driving and that he was not driving when he made the observation in question. Mr. Connor also testified that, in connection with his diabetes diagnosis, low blood sugar can cause him to experience double vision and memory issues. He acknowledged that he had not eaten dinner on the night of the encounter and was unable to recall what he'd eaten earlier that day or at what time. Further, when asked on cross-examination about his 90% level of certainty, Mr. Connor conceded that there could have been a 10% error in his calculation of whether the person he selected from the lineup was the person he saw on November 7th, 2006. During his deposition on June 23rd, 2023, almost 17 years after the incident, Mr. Connor reiterated his prior identification once more, admitting that his memory had been refreshed on multiple occasions over the fact. In fact, Assistant State Attorney Madani was present with Mr. Connor in his home in Louisville, Kentucky during his deposition and prepared him by reviewing the materials together in advance. Well, isn't that delightful? Isn't that delightful? We're just going to go on a walk. I'm going to come to your apartment. We're going to make sure you're prepared. Legal analysis. So why is this an issue legally? A pretrial identification procured through unnecessarily suggestive means is inadmissible, unless the state shows by clear and convincing evidence that the identification is reliable and not tainted under Manson v. Brathwaite, Neal v. Biggers, United States v. Wade, where an out-of-court identification is tainted by suggestive procedures. An in-court identification is also inadmissible unless the state can show that it is based on a source independent of the improper procedure. So they challenge the admissibility here. And typically, we do motions, reading streams, but for the way we're doing these sessions, we're trying to get the details, right? So we're probably going to read a lot of the facts portions and skip some of the legal analysis, but we'll get the headers here. So they say here that the identification procedures were impermissibly suggestive. Let's see. 2, the identification is unreliable under the totality of circumstances and the Biggers factors. You need the opportunity to view the suspect at the time of the crime. And again, Mr. Connor never observed any crime, weapon, or suspicious behavior. There's no nexus, they argue. Witness's degree of attention, there's no indication that Mr. Connor paid any sustained attention to the person he saw. He testified that this person was not carrying a weapon or otherwise engaged in any criminal activity. And there was no confrontation or prolonged observation, just a momentary glance at someone who passed by. Significantly, Mr. Connor has repeatedly stated that he did not see anyone in the parking lot area or hear anything out of the ordinary after he observed this passerby. This completely contradicts the chaotic scene described by law enforcement, as well as Mr. Pata's family and friends. Jada Brody, Mr. Pata's girlfriend, was in their apartment on the second floor when he was shot. And then, we have everybody start to show up. Dwayne comes home and all the family members show up. First responders show up. How wouldn't you know that happened? They challenge the accuracy of the prior description. They call into issue the witness's level of certainty. So he says 90%, but then also acknowledges a 10% differential. Length of time between the crime and identification, saying that the initial identification procedure occurred over 7 months after the observation. And then they go through the analysis here and say, hey, look, this should be excluded. So that was a lot. That was a lot. Oh, man. Usually, when I see motions challenging that, it's like, they are aware of the initial photo array where, hey, we think you may have had issues. We don't know if it was independently administered. We don't know if there was instruction, it wasn't recorded, or you messed up by only showing them one array and the suspect was in that array. You didn't try to use like control arrays where they could say, no, I don't see them at all. But we usually don't have these extra events, these extracurricular activities like, oh yeah, they came back to see me 3 more times. Like, I usually don't see that type of stuff pop up. So that was a lot. I think that one was a lot. All right, let's keep going on this docket. We are almost at the 300s in the docket number. And we just did motion to suppress these identifications. So we've got some scheduling, we've got depositions, we've got motion for cost because he's indigent, making sure that anyone that they need gets paid for through the court administration. Depositions. Let's see. Motion to suppress, they're saying, was denied and granted in part. So I wonder what that actually entailed. Maybe it's like denied in part. It's not attached here, so we can't read it. But maybe like, oh, you can't bring in like the multiple identifications or something. But it was a split decision there. Let's see. More subpoenas. And we are in the 300s. Lots of subpoena notices going out to all the different witnesses. Motion for... Oh, I think this is a good one. I think this relates to Von Zamft. Let's see. All right, so defendant's motion for certificate to secure attendance of out-of-state witness Michael Von Zamft. So this, we might not get into the legal analysis on this one either because it's a long one, but let's get some more info on Michael Van Zamft. So defendant Rashaun Jones, and we are all the way in June 13th of 2025. Rashaun Jones moves this court to issue a certificate to secure the attendance of a material out-of-state witness. This is a former Assistant State Attorney Michael Von Zamft. In support thereof, defendant testifies or states as follows. Michael Von Zamft, I hate saying his name. It's like, I don't know, annoying to say. I'm gonna call him Von Z. Served as the lead prosecutor on the Bryan Pata homicide investigation from 2007 until 2021. So that whole time period, remember, Von Zamft is at the top of the food chain there. And he possesses material and necessary knowledge concerning the charging decisions, timeline of investigation, and interactions with law enforcement and witnesses. Mr. Von Z is no longer employed by the Miami-Dade State Attorney's Office and currently resides in the state of Georgia. Of course he went to Georgia. Placing him outside the jurisdiction of this court. Mr. Von Zamft's testimony is essential to the defense's theory of the case and relates to factual issues only. Specifically, his knowledge of the state's evaluation of the evidence between 2006 and 2020, and its repeated decision not to file any charges. Because, kind of debatable in a case like Edric Faust, it doesn't really seem like Edric Faust was on the radar at all in the first 2 decades. But here, especially because he was a friend, he was a colleague, was a teammate, was at the same school, it's not like Rashaun Jones wasn't somebody that was on the radar early on. But even so, they still never brought any charges against him. It's not like the theory for someone like Edric Faust, oh, they get this CODIS hit. That's not something that happens here at all. So the defense, one of their angles is, well, why not? What did you learn since then that suddenly makes your case against him have a better probable cause to even be brought? Especially you're going to arrest him for first-degree murder and then, oh, let's just do second-degree. I don't know. So they want to know. His testimony is critical for this reason. So the basis, they want to know the basis for the decision to file charges in 2021 despite no new material developments. They want to know about his role in the public records litigation involving ESPN and related strategy, and his communications and coordination with law enforcement and key witnesses, including Paul Connor. The defendant will pay all travel, lodging, and per diem expenses as required under Florida statutes and Georgia Code. This request is supported by the affidavit of Sarah Alvarez, the attorney, attached hereto and incorporated by reference, which outlines in detail the materiality and necessity of Mr. Van Zamft's anticipated testimony. So wherefore we request that you grant this necessary material witness warrant. And let's get to the declaration, the affidavit in support. So this is going to be from Sarah. She says, I'm an attorney licensed in the state of Florida, and this is kind of tiny. So she's licensed. She represents defendant Rashaun Jones, and she's making this affidavit based on personal knowledge, her review of discovery materials, sworn testimony, public records, and transcripts. So this is a homicide case that remained uncharged for 14 years. Not because the police failed to investigate, but because the lead prosecutor, Michael Van Zamft, repeatedly determined that the evidence was not strong enough to support a viable and ethical prosecution. From 2007 until 2021, Mr. Van Zamft served as the Miami-Dade State Attorney's Office lead attorney on the Bryan Pata homicide investigation. He reviewed key witness statements, forensic evidence, and photo lineup identification procedures, and made the deliberate decision not to file charges. Then, in 2021, he suddenly reversed course. Mr. Van Zamft declined to prosecute this case for more than a decade. He repeatedly determined the evidence was not strong enough to move forward. Then, with no new material facts, he suddenly changed course and filed charges. The defense seeks to compel his testimony to ask a fundamental question. Why? Mr. Van Zamft is no longer employed by the state attorney's office and resides out of state. His factual account of what led to that reversal is not just relevant, it's constitutionally required to ensure a fair trial. Mr. Van Zamft was the assigned prosecutor on the Bryan Pata investigation beginning in 2007. And this is coming from a hearing in the lawsuit where ESPN's trying to get the records. Remember, they had to sue to get records relating to this case. So this is a hearing transcript from that case from August 3rd, 2020. And it's attached. We've got transcripts. He worked closely with Detective Miguel Dominguez, who was assigned as the lead detective on the night of the homicide, received regular updates, and assessed the evidentiary sufficiency of the case. We've got a supplemental report attached and a summary report by Dominguez. Mr. Van Zamft determined that the evidence, specifically Paul Connor's identification of Rashaun Jones, was insufficient to file charges. So they already said it's not enough. And we have a quote here that they're quoting from one of the exhibits. The information was shared with ASA Michael Van Zamft, where it was determined that there was not enough evidence to file charges at this time. On August 3rd, 2020, Mr. Van Zamft testified as a sworn witness in the ESPN v. Miami-Dade County et al., defending the county's refusal to release police records by claiming the Pata case was still active. However, when pressed as to why there'd been no arrest in 14 years, Mr. Van Zamft stated, there hasn't been an arrest at this time because we've, in our discussions, determined that we don't have enough to charge somebody at the present time and secure a conviction properly. So as he's trying to prevent record disclosure, he says something that the defense is sinking their talons into here. They're like, oh, you didn't have enough, and you have nothing new. We're going to quote you on that. So he reiterated that he would not be comfortable going to a jury with what we have now, and reminded the court that just merely making an arrest doesn't make a successful prosecution. At the time, Mr. Van Zamft had been working on the Pata homicide investigation for over a decade and knew that the same evidence, Paul Connor's statement, sketch, and photo lineup, had been in the file since before he was ever assigned to the case. On August 25th, 2020, Detective Juan Segovia replaced Detective Dominguez as the lead investigator on the Pata homicide investigation. Major Aguiar advised Detective Segovia that the case was of the utmost importance due to a lawsuit being worked by the Miami-Dade County Attorney's Office. Oh, and then that's a quote. So they're saying it's important because of this lawsuit, along with Miami-Dade Police Department Legal Bureau and the Miami-Dade Police Department Homicide Bureau. And that's from Segovia's supplemental report. On September 9th, 2020, the court issued its ruling in the ESPN case, finding in favor of the county, but warning that the active designation would not remain valid indefinitely. Quote, A time will come when it will no longer be proper for the Miami-Dade Police Department to keep the redactions at issue confidential. And they cite to the order. Shortly thereafter, the state reversed course. On November 17th, 2020, the Miami-Dade State Attorney's Office Media Relations Unit disseminated an email to all assistant state attorneys advising. I think it's got to be Kathleen Fernandez Rundle, the state attorney, the lead, the district attorney. So KFR is requesting to know who is working on this 2006 homicide. Please let me know ASAP. How do they not know? They attached the email thread. The SAO homicide counselor replied that the Bryan Pata homicide case was a cold case in the no arrest files, and there had been no contact with next of kin since 2006. What? On August 4th, 2021, Mr. Von Zamft received the following email correspondence from the state attorney homicide counselor. Hi, Michael. As per your request, I was the homicide counselor on the homicide rotation back in November of 2006. Brief packet was mailed to victim's father, Junior Pierre, and I assisted him with the crimes compensation benefits. I had no further contact with next of kin since 2006. On August 13th, 2021, Mr. Van Zamft participated in a video call with Paul Connor to review his previous statement and prepare him to testify. On August 17th, 2021, Mr. Van Zamft signed off on the arrest warrant for premeditated first-degree murder, a crime punishable by death or life in prison. So you didn't have enough to bring this case, and it's him. It's the same guy that signs off for premeditated first-degree murder. After he has this quote at this hearing for this lawsuit to prevent the record disclosure. Oh, we don't have enough. We can't make the right. We wouldn't get it to prosecution. And then you arrest on the top thing. And yeah, that's a capital offense. So on August 19th, and that's important because again, you're going for something that's a capital offense, but you just said you don't even have enough to make arrest, and there's nothing new. So let us put him under oath and question him on the why. How did this go from we don't have enough to you're going to charge with a capital offense with no new information? On August 19th, 2021, Mr. Jones was arrested in this case and subsequently charged with second-degree murder, a crime punishable by life in prison. And this timeline and Mr. Von Zamft's sudden reversal following over a decade of restraint suggests that institutional pressure mounted after the ESPN litigation, and charges were filed against Mr. Jones based on political influence and media attention rather than any evidentiary breakthrough. Only Mr. Van Zamft can testify to the factors motivating that shift. So that's why we need to ask him, and we cannot ask somebody else. Detective Juan Segovia confirmed that this charging decision was not based on new evidence. Instead, he testified that it came from applying a, quote, fresh set of eyes, his own, to the same investigative materials that were there all along. But what did we just learn from the eyewitness motion that we read? Segovia has been there since at least, 2007? Because he sat in on the 2007 interview with Mr. Connor. So, is that fresh eyes just because you have a new title? You were intimately involved in, the best piece of evidence that you guys have, the identification. So, I don't know if that's a fresh set of eyes. But anyway, to the same investigative materials that were there all along. And then they say, see the Fox True Crime podcast, Football Foul Play, The Murder of Bryan Pata, from August 20th of 2024. And I didn't hear about that one, so that might be another one to check out. And then the Segovia Depot. He also confirmed that both he and Detective Dominguez believed there was probable cause for years prior to 2020, further emphasizing Mr. Van Zamft's role as the barrier to filing charges in the case for well over a decade. Mr. Von Zamft is not being called to provide any legal opinions. His testimony is sought exclusively with respect to factual issues, including but not limited to the state's evaluation of the evidence between 2006 and 2020, and its repeated decision not to file charges. Also, the basis for the decision to file charges in 2021, despite no new material developments. Also, his role in public records litigation involving ESPN and related strategy. And finally, his communications and coordination with law enforcement and key witnesses, including Paul Connor. The state will call Detective Segovia to explain why Mr. Jones was ultimately arrested in 2021, but Detective Segovia could not testify as to why the case was declined for 14 years. So again, they're making the argument that we really need this material out of state witness warrant, and we can't get the information, the comprehensive information that we need from anybody else that would be available. But Detective Segovia can't testify to those things. Only Mr. Van Zamft can. Further, Mr. Van Zamft's credibility and pattern of decision-making are directly relevant to the integrity of this prosecution. On March 6, 2024, Mr. Van Zamft was disqualified from prosecuting State v. Corey Smith. I think it's 2004. That is the main case that I think, what's her name? Andrea Ricker-Wolfson, currently presiding over the Courtney Clenny case. She called the rabbit hole going down and trying to unravel the motion to disqualify Van Zamft as prosecutor in this case, and his co-counsel, another ASA, called it like Alice in Wonderland because of how wild of a rabbit hole it was. And she issued a scathing decision disqualifying him and his co-counsel from prosecuting in State v. Corey Smith. And now there's like a civil suit over this as well against Michael Van Zamft. Like, he might have to get his own dedicated episode. There is a lot with this guy. So they're pointing that, they're wrapping that, they're looping it in here. So he's disqualified after Miami-Dade Circuit Court Judge, Miss Ricker-Wolfson, found evidence regarding over 20 years of alleged allegations of misconduct, including instances of Mr. Van Zamft's witness manipulation tactics, and ruled that the prosecution was tainted primarily by his involvement. The court described his prosecutorial philosophy as winning at all costs and concluded, quote, "The prosecutors in this case have lost sight of their responsibility and justice demands their disqualification." Oh, and they attach her order here. In the instant case, Mr. Van Zamft filed charges against Mr. Jones in 2021, despite no new evidence, just 1 year after he testified under oath that the case lacked sufficient evidence for an ethical and successful prosecution. The judicial findings in Smith reinforced the defense's position that Mr. Van Zamft's decision to file charges in this case was driven by political and institutional pressure and a prosecutorial philosophy of winning at all costs, rather than legally sufficient evidence. Also, they have to say that he no longer resides in Florida, so he's beyond this court's subpoena power. But I'm prepared to ensure that his travel, lodging, and per diem expenses are paid in accordance with Florida Statute 942.06 and the Georgia Code 24-13-90. So then she signs off on this affidavit after requesting this out-of-state material witness warrant be authorized. And then we've got exhibits. So from the ESPN and Miami-Dade County hearing, and they trimmed this. I think there's another. They filed a supplemental motion recently in like the last week where I think they include this full transcript. It's like 300 pages, but it's a few exhibits. It's 3 exhibits, and one of them is this transcript. So it might be that we read more of this later, but for the purpose of this motion, it looks like they only included the relevant portions of like 7 different exhibits. So let's just go through them. We've got, let's see, Your Honor, I have to scroll back and forth to find, they're looking for people on the screen. The court says it should work in the fashion that when he speaks, he becomes the center of your screen. So they're explaining Zoom court. There he is. And then Van Zamft identifies himself. He says, Mike Van Zamft, sir. The court, okay, all right, I see him. All right, so let's have him sworn in. So they swear him in, and direct examination begins. It's questioning by Ms. Kabinski. Good morning, Michael. Can you please state your name and title? Certainly. My name is Michael Van Zamft. I'm an assistant state attorney and senior trial counsel with the Office of State Attorney of the 11th Judicial Circuit. And how long have you worked as an assistant state attorney? Since December of 1995. And what division do you work in currently? I'm a senior trial counsel, so I Presumably I'm in the homicide division, but I'm not in any special division because I handle homicide cases, plus training, plus other training. And how long have you handled homicide cases? Well, I've been handling homicide cases ever since it's indiscernible, office in December of 95. I'm not sure I handled homicide cases. And then the court says, sir, could you repeat again? Because on my end, it cut out for a second. Van Zamft says, yes, Your Honor. I've been handling homicide cases since I started in the office in December of 1995. And then question, are you familiar with the homicide of Bryan Pata? I am. And how are you familiar with it? Well, I certainly learned about it initially when it happened through the present, but then I subsequently became the assistant that was working with the police department on the case after the prior assistant was either taken off the case or left the office. And so, do you recall when you started working on the case? I think approximately the end of 2007. I don't have an exact date. I have a small file on the matter, but it is in my office. I haven't been there since February. Mr. Von Zamft, is this currently an active investigation? Yes, it is. And why do you say that? Because the police are actively seeking to follow up on the information they have. Oh, Lord. In session 1, we talked about that, like, witnesses that were the last known witnesses with Bryan Pata, they never did follow-up interviews with. So here we have Von Zamft out the gate saying, it's an active investigation because the police are actively seeking to follow up on information. Are we? Are we really? Are we really? Claire, have a good one. Shout out to Claire over in Ireland. Have a good night. Man, I don't think they were following up when this is happening. They say, and at this point, it's like ESPN is trying to do the heavy lifting and they're fighting them getting access to these records. So it's like the opposite of having their cake and eating it too. They want to block the records that ESPN's getting in and looking through. But at the same time, they're trying to act like somebody's investigating this case. When really, it seems like maybe ESPN was the only one really doing much. So they end up saying they're actively seeking to make an arrest. We're hopeful that there will be an arrest. And we've discussed this over different periods of time and have been looking forward. Did this jump pages? All right, this jumps 3 pages here. So it jumps from 508 to 511. And it starts with the question, so do you need the entire homicide file in order to be familiar with the investigation? No, I don't. Remember, I'm the prosecutor. I'm not leading the investigation. They are. Next question is Mr. Von Zamft. Why hasn't there been an arrest in this case yet? Well, there hasn't been an arrest at this point in time because we've, in our discussions, determined that we don't have enough to charge somebody at the present time and secure a conviction properly. Question. What is the standard for an arrest? The standard? There's 2 different standards, so you'll have to be clear. The standard for an arrest is probable cause, but the standard for the state attorney's office follows, and that I follow, is before we're going to prosecute, we have to have evidence sufficient to prove a case beyond a reasonable doubt. And just because you have probable cause doesn't necessarily mean you have a case beyond a reasonable doubt. And it doesn't make sense to start a case with an arrest and not be successful. If you had probable cause that somebody was a murderer, would you expect them to just be like, we're not going to arrest them though? And I think I'm pretty far in the bucket of like, I think some arrests are like really garbage arrests and people can be stuck in pre-trial incarceration, awaiting their day in court when the arrest was bogus to start with. Like I'm more in that bucket. But still, the idea that, you know, we have enough, but it's not like we don't have the case fully. So this murder happened. Oh, well, we're not going to arrest somebody even if we have probable cause. That doesn't seem right. But okay. It just seems pick and choosy. Ariel's like, yeah, that's what they did with Chris Melton. Man. Oh, wait, like a Michael Van Zamft SNL skit? Do it. Oh, man. So they continue. This answer is still going on. He says that these are the 2 different standards. And just because you have probable cause doesn't necessarily mean you have a case beyond a reasonable doubt. And it doesn't make sense to start a case with an arrest and not be successful. He says, in Florida, we have a speedy trial rule. So the minute you make that arrest, the clock starts ticking. Once that clock starts ticking, the pressure becomes very heavy on the prosecution, unless the defense takes a continuance. If they don't think there's a case, they won't take a continuance and they will push it. That creates problems for the prosecution. And a question, is securing an arrest anticipated in the foreseeable future for this investigation? Answer, I believe so. I'm trying to think of the proper phrase. I would say we have a person of great interest. That's the best way I can phrase it at the moment, without giving any other details. And some of the investigative steps that would have been taken had we not been stopped by coronavirus might have put us in the position where that arrest could have been done. Keep in mind, if the police make an arrest, I can't tell them to, or I can't stop them from doing that. But if they make an arrest and I don't believe that there's enough to go forward, then I would have to drop the charges and we would all look kind of foolish. And again, while we're reading this is coming from somebody who is disgraced. They are not an honorable prosecutor. They are formally disgraced, admonished, chastised. Being like the Florida bar, released a complaint about him earlier this year. That's going to be part of the motions that we see later on in this, but it's something that has rippled through a lot of other cases in Miami-Dade. So this is this guy saying like, oh, well, we wouldn't want to do something where we have to drop the charges, making mistakes. Meanwhile, his reputation is, quite frankly, finding jailhouse witnesses that he can use in multiple different cases to come to court and say, whatever defendant you need me to say confessed, I'll say confessed. Under the offer, under a promise of leniency to the jailhouse snitch. Not necessarily for anything to get out sooner, but for certain perks in the facility where they're being housed. So, to hear this coming from Michael Van Zamft is a wild thing to read. So we have a question here that says, is securing an arrest in this case? And then it jumps. All right, we're jumping pages again. Like 13 pages. Question, we don't know what came before this, right before this, but the question says, what does that mean that you're hopeful? The answer is, well, I believe that we have a person of interest. I believe there are certain things that need to be done to follow up, and if those things are done, and if we get the appropriate information, then I believe the police can make an arrest. Remember, 2 parts. 1, make the arrest, and 2, successful prosecution. Just merely making an arrest doesn't make a successful prosecution. So I'm hopeful that if the follow-up goes as I would expect, and is done the way we're hoping, that we can have both. Right, and what I'm trying to understand is the use of the word hopeful. Is there any point in this case where you have not been hopeful that an arrest will be made? Well, I'm always hopeful that an arrest will be made. However, sometimes information gets stronger, and therefore I have more hope, I guess is the term. Look, everybody would like to see every homicide solved, but just merely solving it doesn't necessarily get a successful prosecution. So when I say hopeful, I mean hopeful. A, that we can arrest somebody appropriately, and B, that we will have the appropriate materials to then go forward with a successful prosecution. Now, if you missed it, remember the timeline is the end of August. In 2021, they arrest Mr. Jones. By November, they say his cellmate, an inmate that he's rooming with, says he confesses to him. After not confessing or snitching on himself for 15 and a half years. So we have a question. Let me ask you this. You testified earlier that, and I'm trying to take notes as you write, so I might not get the quotation perfect, but I think you said, I believe an arrest is in the foreseeable, I believe there will be an arrest in the foreseeable future. Is that your belief? Yes, it is. Okay, what does foreseeable future mean? Foreseeable future to me means sometime in the future that I expect to occur in my lifetime. And I'm 73, and I'm not trying to be facetious about that. I have cases where it took 20 years before we could make an arrest. 25 years. But that was still foreseeable in my mind because of the way things were going forward. Question. But is it your testimony that if the officer's working on a case, or let's say the state attorney assigned to a case, is 30 years old and therefore has a longer foreseeable lifetime, that the foreseeable future is a longer period of time? No, not really. I might have been a little facetious about that. But what I'm saying is I believe that in a period of time that would be prosecutable, that the information will be there. And the pages jump. And then whatever they're asking about, you don't want the police department to make an arrest at a point where you're unable to successfully prosecute, correct? So that would be true. And it's happened before. Question. And it'd be fair to say that you don't want the Miami-Dade Police Department to make an arrest in this case right now, do you? Answer. Well, I don't want them to make an arrest in this case at this time because I don't believe there's sufficient evidence at the moment to fulfill my prosecutorial requirements. But that doesn't mean that one witness, two witnesses, three witnesses interviewed more won't do it. It just means that right now I would not be comfortable going to a jury with what we have. May I add something to that? The question, well, you've answered the question. I'm not looking for additional commentary. Well, I think it might help explain the answer a little more. And Mr. McGuire, probably an attorney for the state, says, well, Your Honor, all I know that they were people of interest, but that doesn't necessarily mean that they're the person using the term of special interest. Well, that kind of jumps. I think this page went backwards. Because this is 534, and this is 533. So, well, Your Honor, we'll skip that one. We'll go to this one. All I would say is my question, if you've answered, I don't. And then the judge says, generally witnesses are allowed to elaborate in their response, so I'm going to allow him to elaborate if we want. So Van Zamft says, one of the things that would be really horrible in any case, it has happened to us, is to arrest somebody, have them sit in jail or a pending trial, and have us later have to drop the charges because we believe that we don't have the evidence, sufficient evidence to go forward with proof beyond a reasonable doubt. That becomes really unfair to the victim's family, who gets their hopes up, but it also is really unfair to that person who may have languished in jail for a while and or has had their life uprooted because an arrest was made on probable cause, but without enough for us to go forward. And I think on the words on paper, I agree. I agree with these words on paper. I'm not sure I think if it's the full basis of Van Zamft's position on this. But yeah, it seems like the disappointment might be we have them sitting and we still can't get something out of them while they're sitting is kind of where I put my eggs in his basket. So the court reporter apologizes and the judge says, hold on, could you repeat that last sentence? You cut out. And the witness says, as I said, it would be unfair to the victim's family. And that's the end. That's the end of the transcript part. So we get into a supplemental report. We've got a bunch of witnesses. And on Friday, March 21st, 2008, at approximately 10:30 a.m., this investigator attended a meeting with ASA Michael Van Zamft at the state attorney's office and provided him with an update on the progress of the investigation. On Thursday, November 20th, 2008, at approximately 7:20 p.m., Detective Juan Segovia and Detective Jonathan Sable interviewed Alexander Matthew Hinson. So this is the guy that was in the parking lot area that night. Let's see. And here is the narrative. Well, it's more. So on Wednesday, January 7th, 2009, at approximately 3 p.m., Detective Pascal Diaz informed this investigator that he interviewed Sherry Abramson's mother, Mary Dore Abramson. Oh my God, they have all that stuff in there. Detective Diaz also spoke with Sherry Anna Abramson. They've got all this. So they're saying they spoke to a bunch of witnesses. They're in February of 2009, and this investigator reviews cell phone records for these witnesses. On Thursday, March 12th, 2009, at approximately 9 a.m., this investigator attended a meeting with ASA Michael Van Zamft, Sergeant Louis Cristobal, Detective Juan Segovia, and Detective Pascal Diaz at the state attorney's office. So he's involved in all of these steps. Van Zamft's name keeps popping up. So there is no, he wasn't intimately involved. He won't have knowledge about this. We need to question him why, if these investigators are doing this job here, you still didn't want to give them the okay to make an arrest. And then Thursday, March 12th, 2009, this investigator interviewed Hinson again, it seems like, and then he provides the following information. So they talked to a bunch of witnesses, but Van Zamft is part of all of that. All right, so here, this looks important. We've got a possible suspect. Case summary. Did this give a date? Okay, November 7th, 2006 at 7 p.m. is the time of the incident. We know what happens at the Colony Apartments, and they do put here a possible suspect, Rashaun Jones. When was this filled out? Because I get that it's notating information from 2006. Did they say above when Exhibit C was filed? No, it's not searchable. They just call out the case summary report. So maybe it was like something prepared the next day. But it'd be nice to know when they put the suspect name in the line. Because all it tells us is the date of the incident. All right, so this goes through, we saw a lot of the chaos, right? So they get this 911 call. First responders arrive at the Kendall district. They arrive on scene and make contact with Jada Brody, the victim's girlfriend, and his roommate, Dwayne Hendricks. Victim is identified as Bryan Pata, who was a current football player for U of M. The investigation revealed that Miss Brody was waiting for the victim to return home after attending the afternoon football practice. As Miss Brody was inside of their apartment, she thought she heard the victim talking outside in the parking lot. Miss Brody exited the apartment and observed the victim lying on the walkway adjacent to the parking lot, bleeding from the head. Miss Brody ran back into the apartment and called 911 for police assistance. As Miss Brody was on the telephone, Mr. Hendricks drove into the parking lot and discovered the victim lying on the pavement. Miss Brody and Mr. Hendricks were unable to provide any subject information. Additionally, an area canvass was conducted that was met with negative results. Dr. Emma Liu, she's the ME, responded to the scene and conducted a preliminary examination of the victim, where she discovered one gunshot wound to the left side of the victim's head. Robbery does not appear to be a motive, as no personal property was taken from the victim. A search warrant was obtained for the victim's residence, which also included the bedrooms of the victim's girlfriend and roommate. However, nothing of evidentiary value was located. Investigation revealed that a witness identified as Paul Connor. So this had to have been prepared. Paul Connor didn't even come into play that day. He called the next day. So they say investigation revealed that a witness identified as Paul Connor, and he no longer lives here. This is old information. Was walking home on the date of the incident when he heard a single gunshot. So he heard a gunshot, not a pop. And then years later, he would say actually sounded like a cherry bomb. But initially he described it as a pop. But here, whenever the summary is filled out, it's a single gunshot. And then observed a male run past him. Mr. Connor was provided with a photographic lineup and identified an individual in the photographic lineup. So this couldn't have been prepared before 2007, because they didn't do that lineup until then. Mr. Connor identified Rashaun Jones as the person who ran past him. However, he indicated that he was only 90% sure. The information was shared with ASA Michael Van Zamft, where it was determined that there was not enough evidence to file charges at this time. Investigation continues. Exhibit D, we've got Segovia's supplemental report. And this one's dated. This is 2021. Let's see. Is this detailing? Which was this one? Is this where they're talking about going on the trip to see? Let's just read it. So this is November of 2021. This is a few months after they've arrested Jones. So they're saying this is an IR. They're continuing the narrative. This is an investigation into the Bryan Pata homicide. On Tuesday, August 25th, 2020, this investigator was contacted by Miami-Dade Police Department Homicide Bureau Major Jorge Aguiar, who requested this investigator attend a meeting. During this meeting attended by Major Aguiar, Detective Dominguez, and numerous other members of the Homicide Bureau, this investigator was informed that due to Detective Dominguez's retirement in the case, he's going to take over the Pata case, right? It's being transferred to this investigator. So this is when Segovia becomes the lead. Major Aguiar informed the investigator that this case was of utmost importance due to a lawsuit being worked by the Miami-Dade County Attorney's Office, along with the Miami-Dade Police Department Legal Bureau and Homicide Bureau. Major Aguiar requested this investigator meet with Detective Dominguez for the purpose of receiving the case file and being briefed on everything in the case. At the conclusion of the meeting, this investigator met one-on-one with Detective Miguel Dominguez, who provided this investigator with the case file, and briefed this investigator on the current lawsuit, where ESPN is suing Miami-Dade County for discovery on this case. Detective Dominguez briefed this investigator on the status of the case thus far. Additionally, this investigator was informed by Major Aguiar and that the Miami-Dade Police Department Homicide Bureau Cold Case Unit would assist this investigator if needed. So yeah, I mean, all signs point to ESPN being the catalyst, specifically the lawsuit, looking for the records. So then we've got, let's see, the order. This, I don't know if this is really important to read, but this is saying that, like, hey, you can't just call it an active investigation in perpetuity. At some point, there's going to be a cutoff, and it's not, we're going to open it up for public access. So that's the substance of this order. Let's see. State Attorney's Office email thread. Yeah, and this is when Kathleen Fernandez Rundle's requesting to know who's working on this 2006 homicide. Please let me know. Office of KFR. And this was November 17th, 2020. Uh-huh. November 20th. Let's get these dates right. November 20th. Yeah, so at the end of August, that's when he becomes the lead. And they're worried about this lawsuit. And then by November, Kathy's like, who's working this? Who is working this homicide? And then there's a response. Says, hey, this is a cold case. Deceased victim, Bryan Pata. According to the report, he was a football player, shot once in the head outside his apartment shortly after he departed practice from the UM campus. The grief packet was mailed to the victim. And I assisted, but I had no further contact with next of kin since 2006. That's not very, I know they put that above in the affidavit, but does it really seem like they're doing much to speak to the family? Like victims advocates, the team from the state attorney's office, if they haven't talked to someone since 2006, and this incident happened in November of 2006, so that means at most they would have had a month and a half-ish if they haven't talked to somebody since 2006. Maybe they could have done more. And again, you have Van Zamft complaining like, hey, the police could arrest and maybe they would, but my team doesn't have enough. Us here at the state attorney's office, we don't have enough information. But meanwhile, they're not making contact with the next of kin. So then we have news articles. They said that they were going to attach a bunch of stuff. Here's a fact sheet. Let's see. Anything different? They say the Miami Hurricanes 6'4", 280-pound defensive tackle who'd grown up in the grip of poverty was a few months away from being selected in the NFL draft. One of the first things he planned to do with his money was buy his mother a house. Instead, he was buried in the beige suit he'd picked out for his draft party. Oh, that's why they're focusing on that stain. They have that prior incident, the Williams rule evidence that they were fighting over about, oh, he said he would like burn you, shoot you take you down in your draft suit. I forget which phrasing went with the draft suit quote. But that was supposedly something that Rashaun Jones was heard by a mutual friend saying that he would do to Bryan. The detectives from Miami-Dade Police Department chased more than a dozen leads in the early days of their investigation. They interviewed more than 100 people, and the investigation report ran to nearly 200 pages. But after more than a decade, the work didn't add up to an arrest or even anyone police would publicly call a suspect. In 2017, and with no new leads, police reached out to ESPN. Maybe a feature on College Game Day or any kind of media attention could produce a break in the case. In multiple interviews, detectives repeatedly told ESPN they believed someone at the university, likely someone with ties to the Miami football at the time, had key information. With NFL dreams in the rearview mirror and middle age setting in, surely some of them had become parents and could grasp Jeanette's anguish. Maybe someone might be ready to talk. So the Miami-Dade Department also declined to comment about the ESPN story on what remains an open investigation. Several Pata family members, including siblings and his mother, had not returned phone calls or texts to the Miami Herald by Wednesday afternoon. But Dave Howell, one of Pata's best friends and a former teammate, said police should continue to pursue all leads in the case. So did Dave Howell not tell Miami Herald for wherever this article is published that he's in law enforcement? I'm just a best friend and former teammate. Doesn't say that he's also in law enforcement. Said police should continue to pursue all leads. We've got a quote. It says, "It's been so long and there hasn't been any more information that's led to an arrest," he told the Herald. And that just leads to more frustration for the family. Pata was a 22-year-old senior and budding star when he was shot in the back of the head and killed outside his home in the Colony Apartments in Kendall on November 7, 2006. Pata, who was expected to be a high NFL draft pick, had just returned from practice. And it looks like there was an ad here in the screenshots. There were no direct eyewitnesses to the shooting. The police department's homicide bureau had long been tight-lipped about the details of the investigation, but eventually released some documents in the case to ESPN. Detectives investigated a host of people, including Pata's ex-girlfriend, Jada Brody, and her twin brother, who was in Boston at the time. But ESPN's report suggested that Jones appeared to be the most viable suspect. The network found one police records cover sheet that described Jones as a suspect, but without explaining any details why. The documents obtained by ESPN also revealed that in the hours after the shooting, Jones, who'd been suspended because of a third positive marijuana test, skipped a mandatory team meeting at the campus athletic center. Well, I mean, so far we've heard, he skipped this meeting, but maybe he skipped the meeting because he was suspended for failing this test. Like, that could be a very logical reason why somebody might not go to this team meeting if they're suspended. The story also says Jones changed his phone number the day of the shooting, and asked another student athlete to borrow money to go out of town. So we haven't heard anything about that yet. So that's interesting. The Sports Network first began working on the story in 2017, but the relationship with Miami-Dade police soured. When the network went to court to ask for more police records, a judge declined to release them, citing an open investigation. But during that court hearing, then Homicide Lieutenant Joseph Zancanato testified that there was a primary person of interest. And then we've got another email with an article. It looks like it's November 12th, 2020. It says ESPN investigation into 2006 murder of University of Miami football star points to ex-teammate as suspect. More than 10 years after the unsolved, they're going to go through the background. An exhaustive ESPN investigation published last week revealed that police detectives had zeroed in on Rashaun Jones, now 35, a former UM defensive back who had once gotten into a fistfight with Pata and also dated the slain player's girlfriend. Miami-Dade police homicide detectives have never made an arrest in the case, and the department was never publicly revealed that it had a suspect in the shocking slaying. Jones, interviewed twice by ESPN, acknowledged to the network that he was a suspect, but also insisted that he was no killer. "Hell no, because I know I had nothing to do with it, so why would it bother me?" Jones told ESPN last year. "What happened 12 years ago happened 12 years ago. It's got nothing to do with me. I didn't do it." Jones, who's from Lake City near Jacksonville, according to ESPN, could not be reached for comments by the Miami Herald. the ESPN article said he was jailed briefly in Columbia County near Jacksonville in 2018 for a probation violation. The story did not say where he's currently living. Several phone numbers listed on databases as belonging to Jones and family members have been disconnected. And then there's a quote here that says, "We have a strong belief who killed Bryan Pata," Zancanato said, according to ESPN, and then just has the author's bio. Then they've got Death at the U, and I think that's the longer series, or this is the article, right? So they have the 7-episode podcast. If you want to go check that out, there's a resource link in the description. If you open it, there's like a bottom of page, there's like a bunch of different things you can check out. But this is the initial article they published. This article is linked directly in the description of the stream. So if you want to read it, it's like the most detailed one. And they don't include it because it's super long. And they've got more emails, August 4th, 2021. So this is right before his arrest. So what are they saying here? "Hey, Michael, as per your request, I was the homicide counselor on homicide rotation in November of 2006. In grief packet, I haven't been in contact with the next of kin since 2006. Attaches the notes. We read this earlier. This is one of the replies we saw. And then we've got a deposition of Sable. Anything interesting here? This is just talking about the photo lineup. So questions like, would it be common to show a person that is already identified someone in the lineup, to show them the lineup again, to show them that this is what you picked out last time, this is your signature? And he's like, I can't speak for Mr. Van Zamft or Mr. Madani. And you don't have an independent recollection whether that was done or not in the video conference on August 13th, 2021. No, I wasn't inside the area. We were talking, but it's like you can't see Christina Diamond. I think, so they're probably saying, like, here's how everyone's sitting in the room. Christina Diamond is a prosecutor. She's probably in the room. And they're like, well, you probably can't see because the way she's sitting. They're using her as an example. Were you paying attention with the conversation? I could have been paying attention on my phone here and there. Did you take any notes? No, sir. Do you know if Detective Segovia took any notes during the interview? I don't know. That's when you and Detective Segovia on August 17th, 2021 get the arrest warrant, correct? Yes, sir. So that was the end of that. Then they do the arrest warrant. Let's see. Approved by Michael Van Zamft, big signature. And again, first-degree murder with a deadly weapon. And then the information. So here we go. This is count 1. Rashaun Trayvon Jones, on or about November 7th, 2006, in the county and state aforesaid, did unlawfully, feloniously, and by an act imminently dangerous to another, and evincing a depraved mind, regardless of human life, although without any premeditated design to effect the death of any particular individual, kill Bryan Pata, a human being, by shooting him, and during the commission of the offense, said defendant charged a firearm or destructive device, and as a result of the discharge, death or great bodily harm was inflicted upon Bryan Pata, a human being, in violation of the relevant statutes, contrary to the form and statute in such cases, made and provided, and against the peace and dignity of the state of Florida. So that's when we got the second degree, and signed off here by Michael Van Zamft, 30th day of August. They've got a 2-pager deposition here. This is Detective Segovia saying, like, well, I always thought I was the fresh eyes. So he's saying in the middle of the answer here, to me, they were always positive. It wasn't coming from a place of not knowing. It was always verifying and never coming from a bad place. To me, it was very much a smooth transition. So you're saying that there was probable cause all along, and on some odd reason, nobody ever arrested Mr. Jones? When you got assigned with this lawsuit scenario and you spoke with Mr. Madani, basically there wasn't any evidence or new evidence to get probable cause. You just needed to confirm all of the evidence that you had all along was still around. Is that correct? Is that what you're saying? Because pretty much. The fact is, nothing else came out of this. There were a few witness interviews and a few things surfaced, but I don't think any of those by themselves would have done it. It was there all along. There was enough probable cause all along, in my opinion, to have arrested Mr. Jones. And then the questioner says, this is helpful, this is helpful. And in a way, I'm clearing some stuff up, and I appreciate it. So what you're telling me is that none of the information that you generated recently to the run-up on the arrest was anything different from what you already had. It was just, hey, everyone's still around and let's get our ducks in a row. The evidence is the same. He should have been arrested years ago. Let's just arrest him. Is that what you're saying? Answer. There were a few interviews that didn't hurt, but helped. Again, I don't know if any of them by themselves pushed them one way or the other. It was always there. I think maybe it helped a little bit. But those words never came out of Khalil's mouth ever. It was more verification as to what do we do next. And then the question. So let's get into these new things and see exactly what it is that you're saying about these new things, and then we can wrap this up. We know that Connor never said anything new that he hadn't said a decade before, correct? That's correct. So Connor's the eyewitness guy. And then that ends the transcript. I don't know why. It looks like these pages are all jumbled the way they were scanned in, because I think this should have been part of something. Yeah. 2016, I think this should have been part of something earlier. And there's no notation that we're going to a different exhibit here. So it's Segovia interviewing people, spoke with Sherry. And then, let's see. This is the order in the Corey Smith case, disqualifying Assistant State Attorney Michael Van Zamft, and Stephen Mitchell was the other ASA. And I wish it was scannable, but somewhere in here she calls it like Alice in Wonderland. So this is the time. I have a thread about this over on X before I even followed the Rashaun Jones case. This is a hot mess. I should probably do a stream on it one of these days. So there we go. Andrea Ricker-Wolfson signing off there on the disqualification. So we are almost at 350 docket numbers. How you guys doing in the chat? Yeah, all the case needed was a guy with fresh eyes. Can you imagine the shock and horror? The Karen Reed. Yeah, it feels like that, right? You are guilty until you prove your innocence. That is how I feel like they're looking at Rashaun Jones here. So, DB says judge is kind wild. Do you mean the judge that we saw over the hearings? Or do you mean, because I just happened to be reading about Andrea Wolfson, Ricker-Wolfson, so I think I'm reading about the wrong judge. God's Devil Dog's like I'm flatlined. Hey, Mary. Hey, Mary. Yeah, Connor the probably could be legally blind at this point witness. With I wasn't wearing glasses, I'm 20/40 vision, I'm nearsighted and farsighted. Sometimes I have double vision if I haven't eaten and I didn't eat that day. And they don't ask him any of this stuff. They don't ask him any of that stuff. Who are they trying to call here? So they're looking to get a witness here. We are, what date are we on? This is stamped June 25th, 2025. And they want George French Jones. So their petition for a writ of habeas corpus ad testificandum. So they want him to be produced. They want to ask him some questions. For the purpose of testifying on behalf of the state in this case. So the state's calling him, they want him produced the 15th day of July. So they have a hearing that day. They want the jailhouse snitch. And that order's great. Oh, I keep forgetting to share that screen. Sorry. It's a weird application the way this pops up. So when I hit the share screen button, I think I have to wait like 10 seconds because it's not catching when I do it the way it pops up. But it was just a real quick application here, and you see here that they're calling him on behalf of the state. They grant that. We've got Tyler Wood entering his notice of appearance. I believe he's the one that came in pro bono. I could be wrong. I forget where I saw that. They've got a notice of appearance of Benita Jones. We have Daniel Perez. Lots of people coming in here filing in appearances. And I really wonder, what brought these extra attorneys to this case? Because that's kind of like are they all one team coming in for a reason? Because I don't see withdrawals. Did Sarah Alvarez say like, look, we need more counsel? Are these people that are catching wind of this case and they're like, this is a little funny. Like, we need to do something. I'm curious. I'm genuinely curious what the catalyst is for this. So, let's see. We've got a motion to secure. Is this in relation to Van Zamft again? Oh no, this one's for Paul Connor. So we've got a motion from the defense for a certificate to secure attendance of out-of-state witness Paul Connor. So you would think the state needs this witness, right? Wouldn't it be the state calling him? Why is the defense filing this? Well, attendance is different than, well, we've gone to go visit somebody. We've gotten their statement. We've gotten video of them saying things. So what's happening here? This is June 28th, 2025. Rashaun Jones is requesting the court for a certificate to secure the attendance of out-of-state witness Paul Connor. They go through the background. Jones is charged. And then Paul Connor is a material and necessary witness for the defense. Mr. Connor has previously given testimony in this case and has knowledge directly bearing on the central issue of identification and the alleged involvement of the defendant in the charge offense. Paul Connor currently resides in the state of Kentucky and is therefore outside the jurisdiction of this court. The attendance of Mr. Connor in person at trial is essential to the fair determination of this cause. His testimony cannot adequately be secured through deposition or video testimony due to credibility assessments, confrontation rates, and the significance of cross-examination before the jury. Undersigned counsel is prepared to comply with all statutory requirements for securing the attendance of an out-of-state witness, including providing for travel and lodging expenses and all of that. And then they request, like, find that he is material and that we need him, issue a certificate of attendance, and order that the state of Florida or the requesting party provide any other information to secure his attendance. So, and then we've got an affidavit here, probably from Sarah again. Yeah, so Sarah Alvarez is signing this again. She's making the affidavit in support and making the representation that he's a necessary and material witness. He's previously provided sworn testimony at a hearing in this case. He's the only purported eyewitness to place Mr. Jones at or near the crime scene, so his identification is central to the state's case. However, his testimony also supports multiple defense theories, including misidentification, poor lighting and visibility conditions, investigative contamination, and police suggestion. Mr. Connor's presence at trial is critical for confrontation purposes. Based upon information and belief, he's out of state, he's in Kentucky, and, we're prepared. We need him. Without him, the defendant will be deprived of the opportunity for a fair trial. So that's that one. And Paul will keep coming into, Paul's going to keep weaving in and out of these motions. I haven't looked at these. I've looked at the ones from this month, and his name is in a bunch of those motions. Him and Michael, they're named all the time. Let's see. Another petition for writ of habeas corpus. Let's see. Who's this one for? Oh, okay. So they've got another one here for George French Jones, the jailhouse snitch. It looks like they had to change the day. And that was granted. Aha, this one. So we've got July 3rd, 2025, notice of intent to rely on evidence of other crimes, wrong, or acts. So this is what the hearings we watched in session 1 dealt with, right? Hearings to see, is this type of information, is it Williams rule evidence? And if it's Williams rule evidence, can it come in? Can the defense successfully challenge it? Or is it not even Williams rule evidence and the defense has a less likely chance to getting it suppressed and keep it from coming in? So comes down Catherine Fernandez-Rundle, this is the state having to say that we are going to rely on evidence of other crimes, wrongs, or acts. So they say pursuant to the Florida Evidence Code, section 90.4042A of the Florida statutes, they seem to follow the federal numbering, files this notice of intent to rely on evidence of other crimes, wrongs, or acts. And they have to do this under the case Williams v. State. And set forth below is a written statement of the acts or offenses that the state intends to offer as evidence to prove material facts in issue, including proof of motive, intent, knowledge, identity, or absence of mistake or accident. So, one, that Rashaun Jones pointed a black small revolver at Dave Howell during the 2004 to 2005 school year. Did he testify to that? We just watched that. Didn't he say he kind of just lifted it up? Maybe I missed the part where he described it as pointing, but here it's being written, a gun was pointed at Dave Howell. During the summer of 2004-2005, Rashaun Jones got into a fight in or around Eric Monker's dorm room with Bryan Pata. At that time, Rashaun Jones told Bryan Pata to clip up, which was heard by Dave Howell and Eric Monker. So, very light description of this fight in the dorm room, where Bryan actually punches Rashaun Jones in the face and doesn't let him leave. During the fall of 2005, Dave Howell and Rashaun Jones got into a fight in the locker room. After leaving the locker room, Rashaun Jones said he was going to have to clip up. Yeah, we're missing a lot of substance from this story too. What do you guys think? If you were here for session 1, if you watched that testimony of Dave Howell, do you think this is a fair representation to the court of what these incidences actually entailed? And for what it's worth, it might not be, the state might not have probed enough or gotten thorough information from Dave Howell. But do you think it's a fair description of whether it's the state leaving something out or the state never got something from David, it's Dave himself leaving something out? Because this seems gappy to me. This seems gappy. Yeah, I'm with DB. I'm with DB on this one. And then that was it. Those are the only ones that they say that they are planning to introduce at this time. Which is kind of surprising, because to me that suggests that as of July 3rd, in addition to the eyewitness stuff, that this is really what's making their case. So, okay. Then we've got motion to exclude. So this is the defense's response. And this one, let's see. Right? Yeah, okay. So comes now Mr. Rashaun Jones by and through his counsel. Hereby respectfully moves this court to exclude evidence of other bad acts that the state seeks to introduce pursuant to the Williams rule, and to hold a hearing on the matter. In support of this motion, defendant states as follows. The state filed this notice of these acts on July 3rd that we just looked at. The state's notice is timely. The state's notice lists 3 allegations of other bad acts and uncharged crimes that it seeks to introduce into evidence at the defendant's trial. The state's notice also lists the state's theories of relevance, though it does not specify which theory of relevance is to be attributed to which bad act. The defendant is moving to strike the Williams rule notice and to exclude any evidence of these allegations at trial because they are irrelevant and will serve to only unfairly prejudice the defendant. To the extent that these uncharged crimes harbor some relevance, that relevance is substantially outweighed by the accompanying unfair prejudice. And then we're getting a cite here. So before admitting Williams rule evidence, it is incumbent upon the trial court to make multiple determinations. So you can't just blanket and say yes. Some of these determinations include whether the defendant committed the prior crime, whether the prior crime meets the similarity requirements necessary to be relevant as set forth in our prior case law, whether the prior crime is too remote as to diminish its relevance, and finally, whether the prejudicial effect of the prior crime substantially outweighs its probative value. As the above-mentioned requirements suggest, the determination of whether evidence properly may be admitted as Williams rule evidence is highly individualized, factually intensive inquiry. The defendant is requesting that the court hold a pretrial hearing to make the appropriate determinations, which we watched in session 1. And this one was written by Tyler Wood. And here we go. Here's Paul Connor's name. I see his name in the description here. What do we have Paul Connor popping up for here? So July 8th comes now. The state moves this court to admit and play at trial the prior video recorded testimony of state witness Paul Connor, and in support thereof states the following. So if you saw this trial, you might remember There's a video of Paul Connor. He's not testifying in person. The defendant was charged with second-degree murder with a firearm. Paul Connor is listed as a state witness. His testimony is essential. He identified the defendant in a lineup as the person whom he saw leaving the scene of the homicide shortly after hearing a pop-like sound. On September 3rd, 2021, the state filed a motion to perpetuate testimony of Mr. Connor, which they attach. The court granted the motion, and Mr. Connor's testimony was perpetuated during an author hearing that took place from February 28th through March 2nd, 2022. It should be noted that Mr. Connor, who was a University of Miami professor at the time of the homicide, had moved to Ohio at the time of the Arthur hearing. At the trial of this matter, the state would have called Mr. Connor for the exact same testimony. In order to prepare for trial, the state made numerous attempts to contact Mr. Connor beginning in May of 2025. In addition to calls from the state attorney's office, Miami-Dade Sheriff's Office Detective Juan Segovia started reaching out to Mr. Connor. Detective Segovia first attempted to reach him by calling Mr. Connor's cellular telephone number. Although the number is active and accepts calls, no one's answered the telephone or returned any of the over 15 voice messages left by Detective Segovia. Detective Segovia also emailed him at the email address that he previously indicated was his preferred method of communication, but never received an answer. Due to the lack of response, Detective Segovia reached out to the Toledo Police Department and the local FBI office for assistance in locating Mr. Connor. After numerous attempts, a Sergeant Roy Kennedy notified Detective Segovia that an individual named Kyle Corbett now lived at the address previously owned by Mr. Connor, and that Mr. Connor could not be located in Toledo, Ohio. Further research by Detective Segovia revealed a possible new address in Louisville, Kentucky, and he contacted the Louisville Police Department's Homicide Bureau for assistance in locating Mr. Connor. Contact was made with the leasing office at that address, and they indicated that Mr. Connor did not live there. MDSO has no further leads on Mr. Connor. At this point, it appears that Mr. Connor is unavailable as a witness. The party seeking the admission of a witness's former testimony carries the burden of demonstrating the witness's unavailability for trial, and that the party exercised due diligence in its attempt to procure the witness's attendance or testimony. The trial court is entitled to rely on the prosecutor's assertions to make its determination as to witness unavailability. So, very important guy, not available. They can't reach him to get him, and trial's coming up. If the prior testimony of Mr. Connor is played to the jury during the trial, and the prior identifications of the photographs that he made during that testimony were introduced, the defendant will not be deprived of his Sixth Amendment right of confrontation, as it is explicated in Crawford v. Washington. Furthermore, because the trial court determined that Ullery was unavailable, that's the witness in the case, and that Parton had an opportunity to cross-examine her in a prior trial on the same subject matter, Parton was not deprived of his Sixth Amendment right to confrontation. If the court ultimately makes a finding that Mr. Connor is unavailable and that his prior perpetuated testimony, during which he was offered for cross-examination by counsel for defendant, can be presented to the jury, the defendant's constitutional right to confrontation will not be violated by the presentation of his prior testimony to the jury. So they say, can we please use his Arthur hearing testimony from February 28th, 2022 at the trial in 2026? Now, if you had doubts, put yourself in the shoes of someone who reported something and you thought maybe you had doubts and you realize that now that trial's coming along, you could be testifying to something very serious even though you're not sure. But there's like gravamen behind your testimony now because your testimony was just used a few years ago to deny someone bond. You saw them in custody. And now they're about to have their trial. Do you think a decision to not want to be in contact, not want to return these phone calls, might be because you are not confident enough in what you thought you saw or the significance of what you did see? Maybe you did really see a person, but you can't attribute it to the crime that occurred. Might that explain why you might not return phone calls? And that's not something you can get into if they're just going to play a video. You can only get into future information, something that would have happened. Hey, Mr. Connor, since 2022, when we last saw you, it's been difficult to get in contact with you. Why? That's not something you could have asked him in 2022. So whatever cross-examination is preserved in that Arthur hearing video would be missing the future context. So, yeah, they lost Paul. He's gone. Have they tried visiting? I mean, they visit him all these other times. They visited him all these other times. Did they try finding another residence? Seeing if maybe his phone bill or like whatever phone is still active, if it comes up somewhere? I don't know. Next up on the docket, they have, let's see, motion for continuance. Let's see, he's motion for state charge continuance. Defendant respectfully moves this court for continuance. And they say why. Like, look at all these dates. We're arrested in August of 2021. In September, we invoke reciprocal discovery. In September 21, the state files its initial discovery. January 31st, 2022, the court granted defense a continuance. September 12th, 2024, the court granted a second defense continuance. December 10th, this trial was set for July 14th, 2025. On February 8th, 2025, undersigned counsel entered a notice of appearance. Shortly thereafter, counsel obtained the discovery previously provided to prior defense counsel and requested that the state provide all other discovery that remained outstanding. And we read that whole thing. We read all of the stuff that they were requesting. Let's see. As detailed in defense's second motion to compel, most of the compelled materials remain outstanding, as does the additional discovery that defense requested following the court's ruling on defense's first motion to compel. This outstanding discovery constitutes Brady and Giglio material. See Exhibit A attached and incorporated by reference. So let's check that out, because I don't think I saw that as a clickable document. So second motion to compel. What are they looking for? Because after it was granted. Oh. Oh, what? Okay, wait. So on April 17th, 2025, this court granted the defense motion to compel, right? So we heard that order. I think I breezed by it. I was like, oh, the court granted they're just going to say, turn it over, you have 30 days. And ordered the state to produce the materials listed within 30 days. On April 22nd, so within 5 days, after the court had signed and entered the April 17th order, the assistant state attorney emailed the court and defense counsel requesting the matter be placed back on calendar for reconsideration. Over defense objection, the matter was set for hearing on April 28th, 2025. At the April 28th hearing, the court granted the state request for reconsideration and amended its prior order to require production of the following items only. So subpoena for the University of Miami judicial file, the MySpace subpoenas. That's it? Oh, and then all subpoenas for cell phone records, including but not limited to the 9 phone numbers identified in discovery and all responsive materials. So where is all the other stuff that they asked for? Since that time, defense has followed up with requests for additional discovery, including, first up, an unredacted version of the lead sheet. All discovery related to state witness George French Jones, the snitch, the jailhouse snitch. Any correspondence from George French Jones and law enforcement or the state attorney's office regarding this case. Any formal or informal agreements, promises, or understandings regarding benefits or favorable treatment, actual or perceived, from the state or federal government in exchange for his cooperation in state v. Rashaun Jones. Any request by George French Jones for such benefits. Any offers by the state to provide such benefits. A list of any other cases in which George French Jones has cooperated with the state and any related benefits or favorable treatment he received. And then his complete criminal history. Guys, I cannot wait until, I'm excited to watch the trial with you guys, but I cannot wait until we get to what made me want to do this whole deep dive. And that's recent stuff that's filed where we're going to see a deposition that attorney Jeremy McLymont did in another case. Not related to this Bryan Pata or Rashaun Jones at all. The only overlap is that George French Jones is also a jailhouse snitch for the defendant in the case where Jeremy McLyman is representing the defendant. And in this deposition, McLyman has the jailhouse snitch, George French Jones, saying that Michael Van Zamft offered him benefits for cooperating in both cases, Jeremy McLyman's case and the Rashaun Jones case. And I read that and I was just fuming. I was reading it last night. I was fuming. I got up this morning. I put together the stupid little trailer, put together all this information, and I went live with you guys at 2 because it pissed me off so much to read that we've got a jailhouse snitch who's saying, like, I was conferred benefits, I was offered leniency for snitching in 2 different cases by the same prosecutor who's already disgraced and has a pattern of doing this with jailhouse snitches. So here, this is where it seems like the attorneys seem to know that this is already going to be some BS. In July of 2025, they're like, we still need you to turn all of this over. What is going on with this George French Jones that you're trying to transport as a state's witness to come testify? We want all the information about him. Who is it? What's up? Like, this is, ooh. I was mad last night. It was like 1, 2 in the morning, and I'm like, I should go live right now. But here we are. So they say to date, the following items remain outstanding. Bryan Pata's universe. So she reduces. Are you serious? So it seems like they might have gotten phone numbers, right? We don't have the phone number bullet point here. But besides the phone numbers, we have, hey, the judge, they asked for reconsideration, and the judge pared it down to just the limited amount of items below. The judicial record from the school, the MySpace subpoena, and then what do we have here? Hey, we're actually still waiting for the judicial file and the MySpace materials. So they didn't even turn over 2 of the 3 things in the very constrained, limited order to compel. So anyway, under Brady v. Maryland, the perpetually ignored case law, the state is constitutionally required to disclose evidence favorable to the accused and material to guilt or punishment. This duty includes both exculpatory, and we read this earlier, it's the same language. The state's failure to provide this material continues to prejudice the defense and impairs Mr. Jones' ability to adequately prepare for trial. So again, this is a motion for continuance. So wherefore, the defendant respectfully requests this court enter an order compelling the state to respond to these outstanding discovery requests by either producing the materials or providing a statement that they don't exist. Oh, that was attached as an exhibit, right? So we got to go back up. But that's why they're going to say, I mean, this is yet another, they're missing information, trials around the corner, and even though the defense is trying to work diligently, they can't work on something that they don't have available to them. So let's see. Where was that exhibit? Was it this one, most remain outstanding, or were we further? Yeah, okay, so we were here then. So between March 2025 and present date, the defense deposed 27 state witnesses in an effort to have this case prepared for the July 14th trial date. On June 24th, 2025, the court held a hearing for defense's motion to suppress identification. I would love to watch that hearing. Maybe it's like available somewhere in the ether. On July 3rd, 2025, the state amended its witness list to include 187 new witnesses. So, I mean, clearly those 187 witnesses weren't available when they decided to issue the arrest warrant or the indictment, the second degree, because this is now 3.5 years later. On July 8th, 2025, the state amended its witness list to include an additional witness designated as an expert. Then we have the defense has taken only 2 continuances in this case and respectfully requests a state charge continuance of the current trial to allow the defense to take depositions of witnesses listed in the state's amended witness list, because they've got to go through 187 potentially. Take the deposition of Detective Pat Diaz, who played an integral role in this investigation, and who defense has thus far been unable to depose despite good faith efforts. So they're going to detail their attempts. So on June 4th, following their inquiry as to the detective's availability, the state advised that Detective Diaz was unavailable until July because of a family emergency, so they proposed July 3rd for deposition. On June 23rd, in response to defense's attempts to confirm the July 3rd setting, the state advised that the detective was dealing with a family emergency and did not want to reach out to him until June 27th or the 30th to confirm. On June 30th, the defense again attempted to confirm the July 3rd setting with the state. On July 2nd, the state advised that retired Detective Diaz is not available tomorrow. He's on vacation with a very bad reception. He told me he would give me a call when he returns from vacation early next week. On July 8th, the state advised that Detective Pat Diaz is not available to be deposed this week. He's available Monday morning. He does not have a copy of his notes, however. I'm going to email them to him, but he may not have much time to go through them prior to his deposition. Please let me know if you would like to depose him then. And then they attach that correspondence. And then they also want to obtain the outstanding discovery. They need this continuance to obtain what the state has not turned over still, particularly the Brady and Giglio material, detailed in defense's second motion to compel. So they say, like, look, Florida's discovery rules are designed to prevent surprise by either the prosecution or the defense, and their purpose is to facilitate a truthful fact-finding process. The state's obligation is to provide the names of all witnesses, not just the ones they intend to call at trial. Just because a person is listed in a police report, but not listed as a witness, does not give the defendant sufficient notice that the person will be called to testify at trial. So help us pare it down. Moreover, the knowledge of police officers is imputed to the prosecutor for purposes of the rule requiring the disclosure of persons known to the prosecutor to have information relevant to the offense charged. In addition to the rules of discovery, the Brady rule imposes an affirmative duty on the prosecution to produce the appropriate time-requested evidence, which is materially favorable to the accused, either as direct or impeaching evidence. Further, discovery must be furnished in sufficient time to permit the defendant to make use of it without having to forfeit his right to a speedy trial. So this is how it all wraps up, right? The state's delay has inhibited defense's ability to be ready for trial on July 14th, 2025. So this is why we're asking you to grant a continuance charged to the state, please. So they send this in, and we'll go back to the docket. Oh, this is fun. Landless says, I'm unfamiliar with this case. We are deep diving it together. We are learning as we go. It's a time. It is a time. Is this a joke? Did I just chat GPT all of this? Or Gemini? Hey, Gemini, can you create, can you LARP as, a really crappy case? Yeah, how do we get 180? I know why. It's probably from the ESPN reporting. But how do we get these 187 new witnesses in 2025 when we arrested Rashaun Jones in August of 2021, and in 2021 and 2020 before the arrest, Michael Van Zamft is testifying in this ESPN lawsuit. Oh, we can't arrest them. We don't have any new information. We could if we would, but we can't. It would be embarrassing. What exactly did they have available to them when they effectuated the arrest and came with the indictment? Right? It wasn't just an arrest. It was also an indictment that Van Zamft signed off on by the end of August of 2021. If we don't have these 187 witnesses disclosed until 2025. That's hilarious. I see EJF saying, obviously they're admitting to being in a gang by choosing the number of 187. So, it's a lot. So next on the docket, where are we? We're getting towards the 400s, which is getting us close to halfway through, right? Doesn't look like it based on this scroll. So they have this motion for continuance. The motion, they want to take the deposition of the incarcerated witness, George French Jones. Did they have to argue hard for this? How much did they have to write for this? Okay, no, they're just asking permission. It's like 2 pages. Additional discovery exhibit. Oh, Lord. You're kidding me, right? Okay, let's look at these dates before we toggle over. Guys, we have this motion for continuance we just read on the 8th of July, 2025. On the 9th, suddenly we're capable of turning things over one day, even though we've had more than one motion to compel. Suddenly, a day later, we're just fully capable of turning things over. So we've got courtesy copy of phone records, courtesy copies of witness statements and other items missing by defense provided in person, courtesy copies of media collected by police provided on USB, screenshot from Kareem Brown sent April 25th, 2025, composite witness interview form sent April 30th, 2025, Jorge Molina, that's a sketch artist, his CV, sent May 6, 2025. That must be the expert that they mentioned. Facial ID catalog, sent May 8th. Courtesy copies of the phone records and subpoenas. Jail call, shared via evidence.com. And witness priors, sent July 9th, 2025. The following are unavailable to be located or no longer exist. So a subpoena for Bryan Pata's University of Miami judicial file, and subpoenas to MySpace in connection with this case and all responsive materials. So even though we have reference to some MySpace posts where it's like, I know who unalived this guy, it's referenced in one of the reports somewhere, they don't have it. It's gone. From November 10th, which would have been 3 days after the killing, somebody posted this on Bryan Pata's MySpace somewhere. Like, okay. I have so much confidence in this. This is going great. This is going great. All right, so they granted the continuance here on the 9th. They've got trial hearing set, order granting defendant's motion for certificate to secure attendance. Is this for Paul or is this for Van Zamft? Let's see what this one is. All right, so this one's for Paul Connor. So they order that they can get this material witness warrant for Paul Connor. And defense has to incur deposition transcript costs. Let's see. And they also authorize the defense to incur costs of defense eyewitness identification and memory experts. So he wants to hire a memory expert. So that's cool. I didn't see a motion. I didn't see a document for a motion for that. Does it tell us how much that costs? Let's see what his limit is. All right, so they were asking to retain Dr. Nadia Schreiber Campo at a rate of $300 per hour for a projection of 30 hours a week. And let's see. Plus reimbursement for all reasonable and necessary case-related expenses like travel and all that. So, cool. So, if they had that witness at the trial, I didn't see that part of the trial. But because Rashaun Jones is indigent, the court has to authorize fees for this type of stuff because it's going to be billed to JAC. Let's see. Notice of intent to rely on evidence of crimes. Oh, so they amended it, right? So they're going to add more. So now we're on July 11th. They add this bullet point. So they add this prior of, in the months leading up to Bryan's murder, Rashaun Jones threatened to shoot Bryan Pata using the words, burn him and put him in a casket in his draft suit. So that was the language. These threats were told to Bryan's brothers, Edwin, Fednall, and Edric Pata by Bryan. So all 3 brothers come in. This wasn't previously noticed. But by July 11th, all 3 brothers said Bryan told them that Rashaun Jones said this to him. And this is oddly after, at his funeral, he is in fact buried in his draft suit. So next up, motion to exclude, strike, or exclude perpetuated testimony. So they're addressing, I think they have to address it because they just updated it. So this is for the video of what's it called? The Arthur hearing of Paul Connor. So on February 24th, 2022, the state's motion to perpetuate testimony was granted over defense objection. On February 28th, 2022, Mr. Connor traveled to Miami to testify at the Arthur hearing. The state brought camera equipment to film his testimony. Did they know? Did they foresee this being a problem? Were they like, all right, it's 2022. It's going to be like at least 3 years before we actually take this guy to trial. And our key witness is getting kind of up there in age. He's got diabetes. Even though we didn't ask him about the diabetes for the identification, now we're concerned about his health because we're worried he won't be available. So let's just bring this camera equipment to record him just because. It's almost like they knew. So during the hearing, despite requests from defense counsel, Mr. Jones was not permitted to sit at counsel table. What? He was confined to the jury box and unable to communicate with his lawyers or assist in his defense while the state's most important witness testified against him. Are you kidding me? Defense's cross-examination was limited by the early stage of discovery, which was incomplete at the time of the hearing. On June 27, 2023, Paul Connor gave a deposition via Zoom. During his deposition, Mr. Connor was inconsistent on multiple points. On January 29, 2025, Mr. Jones' case was set for trial on July 14th. On July 8th, 2025, the state filed a motion to admit perpetuated testimony of Paul Connor. In this motion, the state asserts that Mr. Connor has not responded to Detective Segovia's calls or emails. Although Mr. Connor had already relocated from Ohio and was living in Kentucky when his deposition was taken in 2023, Detective Segovia first reached out to the Toledo Police Department and the local FBI office for assistance in locating Mr. Connor. And they say, see the motion. After conducting further research and finding a new address, Segovia contacted Louisville Police Department for assistance in locating Mr. Connor. Contact was made with the leasing office of that address, and they indicated that Mr. O'Connor did not live there and that they had no further leads. The assertions in this motion are based on multiple levels of hearsay and are not substantiated by any records, sworn testimony, or affidavits. Like, for example, they could have gotten an affidavit from the Louisville homicide detective who, supposedly, made efforts to locate Mr. Connor, or an employee with the leasing office at Mr. Connor's last known address. Further, no subpoena has been issued to Mr. Connor at his last known address, so they didn't even try like the first thing that you would do. So Paul Connor is the state's most critical witness, with a footnote. And then according to Mr. Connor, as he was walking home to the Colony apartment complex on November 7th, 2026, he heard a pop noise and then crossed paths with the person who was walking out of the north parking lot entrance to the complex. As Mr. Connor turned left into the parking lot and walked to his building, he passed the area where Bryan Pata's body was found that evening. Mr. Connor stated that he did not hear or see anyone else in the area on his walk home through the parking lot that night. The following day, upon learning that there had been a shooting at his complex the night before, Mr. Connor called the police to report hearing a pop noise and seeing this person around the time of the shooting. Almost 7 months later, on June 24th, 2007, the police presented Mr. Connor with a photo lineup and he selected Mr. Jones's image, indicating that he was 90% sure of his choice and noting that the facial hair was not the same as that of the person he saw in the area in the night on question. So back to the motion. Particularly in light of the substantial efforts the state has made to locate Mr. Connor in the past, the state's minimal efforts to secure Mr. Connor's presence at Mr. Jones' trial cannot be characterized as reasonable diligence, as required under Florida law. On at least 3 occasions, with a footnote, Mr. Connor testified that he was certain that detectives traveled to his residence in Toledo, Ohio in 2017 or 2018. However, Detective Segovia testified that following June 24th, 2007, the first time that detectives made contact with Mr. Connor was when they traveled to see him in Ohio in 2020. So, someone's either wrong about the dates or maybe we're imagining a visit. So they're putting a footnote there for why they're saying on at least 3 occasions, because there's some lack of clarity there, because nobody took notes. Law enforcement traveled out of state to locate Mr. Connor. First, on September 16th, Detective Segovia and Sable traveled to Toledo. On August 13th, 2021, right before the arrest, Detective Segovia and Sable traveled to Toledo, Ohio to locate Mr. Connor and assist him in connecting with prosecutors via Zoom to discuss his previous statements, as well as his availability to testify at hearings, in deposition, and at trial. And then on June 27th, 2023, ASA Madani personally traveled to Louisville, Kentucky to facilitate the defense's deposition of Paul Connor over the Zoom platform. Now, as trial approaches, the state has not demonstrated the same level of effort to secure Mr. Connor's appearance for live testimony. On July 10th, 2025, a private investigator working with the defense located an active phone number for Mr. Connor. When called, the voicemail greeting identified the number as belonging to Paul, and a return call from the number was received shortly after the voicemail. So, okay. So this device returned a call for this presumably unknown number, but this same device didn't want to return a call from Detective Segovia when he called 15 times. That's critical. You should be able to cross-examine a witness on that. Why did you not want to talk to them? Is there a reason that you're reluctant? So they go through legal analysis, and even though we would normally read this, because we're going through a full docket and not just new motions, we'll get the bullet point. So here, perpetuated testimony is inadmissible unless the witness is unavailable at the time of trial. So they're saying they didn't try hard enough to make sure he's not available. There's been no such showing that he's unavailable. Mr. Connor is alive, apparently reachable, and has not been subpoenaed. The mere fact that he has not answered emails or calls, or that his address potentially changed, does not satisfy the state's burden. The state may not continue to rely on perpetuated testimony when the witness is still alive and capable of appearing with reasonable diligence. It would be a confrontation clause violation, is the next argument. Significantly, oh, this is a great argument. I didn't even see what they were cooking up when we read this. I just was pissed off. This is great. So the Sixth Amendment and Article 1, Section 16 of the Florida Constitution guarantee a defendant the right to confront adverse witnesses. And he's adverse because the state is calling him and he's saying that you're the guy that was there at the scene of the crime. You're putting the defendant in the location. Very adverse witness. Admission of perpetuated testimony where the state has failed to demonstrate true unavailability violates these confrontation rights. Significantly, this is such a good argument. Mr. Jones' confinement to the jury box during Mr. Connor's testimony at the Arthur hearing deprived him of a meaningful opportunity to assist his counsel, which is a crucial component of that confrontation right. So the state's saying, you were able to cross-examine Mr. Connor at this Arthur hearing, so your right wouldn't be deprived if we rely on this video that we conveniently brought this camera equipment that day to record. It's fine. You had your right to confront him. It's the same thing. But did he really, if the defendant wasn't able to speak with counsel during that hearing? And I don't know where this argument's going to land, but I think it's a great argument. I didn't even see it coming. Didn't even see it coming. So they say here, the court should not allow a hearing conducted under such conditions where the defendant is confined apart from his counsel to substitute for live trial testimony. Moreover, Florida statute section 90.80322 permits use of former testimony only where the defendant had an adequate opportunity and similar motive to cross-examine. At the time of the Arthur hearing, discovery was far from complete, and Mr. Connor had not yet been deposed, so they didn't even get to cross-examine him on that stuff. Thus, defense did not have access to impeachment material that was not in existence until Mr. Connor was deposed in 2023. And I know the state must have won this, or maybe I don't want to say like maybe somebody died, but I guess if circumstances change from the filings of these motions to the time of the trial. At the trial, I believe we had these Arthur hearing videos were what we had for Paul Connor's testimony. So the state ultimately wins and is able to use the perpetuated video testimony. But I think these are compelling arguments. I think these are very compelling arguments. So, and then they say the state has not exercised reasonable diligence. So, before a witness can be declared unavailable, the state's required to show reasonable diligent efforts. They didn't even try to subpoena him. So, they say, like, look, don't let the state use this old video from the Arthur hearing. He's got to come back in person. And we would have a right then to confront him on stuff we couldn't confront him on in 2022. And we also get to see if he can hold up his story another time, because if he's been inconsistent in the past, it's only fair to see if he'd be consistent at trial in front of the jury when it matters. So, all right, then we've got some hearings being set on the docket. Bunch of subpoenas. We are in the 400s. Look, we are breezing through. If we make it to 450. Oh, no, we got to 446. Oh, we've got a motion to strike state's William rule notice. And this is only July 14th here, so all those subpoenas went out. It's been like 3 days since the last filings we were reading. And they've got, let's see, defendant's motion to strike state's William rule notice. They move this court to exclude evidence of other bad acts that the state seeks to introduce pursuant to the Williams rule and to hold a hearing on the matter. And the defendant states as follows. They want the state's notice stricken because it fails to provide the time and place of the alleged offenses with the specificity required of an indictment or information. So, according to statute, the state shall furnish to the defendant or the defendant's counsel a written statement of the acts or offenses it intends to offer, describing them with particularity, the particularity required of an indictment or information. Florida statute also requires an indictment or information to allege the time and place as definitely as possible. While the exact date is not always required, particularly when it's not known, the state must exhaust avenues of inquiry which may have produced more precise dates. So if you can narrow it down, like I remember it was Christmas time, do that. Because the state's notice wholly fails to sufficiently inform the defense regarding the allegations, the defense is unable to effectively challenge the factual circumstances of the allegations or otherwise explore possible defenses. And this is a good thing to argue, generally speaking, because if you come out and be like, well, I know what date that happened, you concede that the thing happened at all. So at this point, if you can still fight to have it be founded, why not? So the first example is the Rashaun Jones pointing a black small revolver at Dave Howell during the 2004 to 2005 school year. They say that the notice does not specify location at all, and the offered date and time of the offense spans roughly 9 months, the length of a school year. Next, the issue with during the summer of 2004 or 2005, Rashaun Jones got in a fight in or around Eric Monker's dorm room with Bryan Pata. At the time, Rashaun Jones told Bryan Pata to clip up, which was heard by Dave Howell and Eric Monker. This notice provides a location for the uncharged crime, but provides an even greater time frame in which the uncharged crimes may have occurred. The alleged events could have occurred or not occurred. They don't concede at any point over the course of a year. And then we've got, let's see, the fall of 2005, the locker room fight. This notice provides a location, but only limits the alleged time frame to within 3 to 4 months of a particular year, the fall. And then this newer one that was added, where all three brothers were told by Bryan that Rashaun Jones said, I'm going to burn him, put him in a casket in his draft suit. They say this notice does not provide a location at all. Further, it does not provide sufficient specificity regarding when the alleged offense occurred. In the months leading up to Bryan's murder, only specifies that the threats occurred before the murder. Specifying months as a unit of time does not limit the time frame unless the state specifies how many months. So that's their dispute. Don't let this stuff in. It's not particularized. And then, all right, and then the state files supplements to clarify this, it looks like. It's kind of interesting reading this backwards, though, because we know the details that were testified to, and it's just the way it's in the state's motion is such a different picture. It's just like, oh my God, he started a fight with someone in the dorm room, but then you hear in the testimony it's actually him getting punched in the face. Like, he wasn't the physical aggressor. So, good times. So let's see, they're going to spell out the specifics, it looks like. Let's see. Let's read this and see if it's different. So during the summer of 2004, and the footnote says Dave Howell remembers this incident occurring in August of 2004, while Eric Monker remembers it to either be August of 2004 or 2005. Both Dave Howell and Eric remember the same event and substantially similar statements being made. So prior to the school starting, but after summer's football practice had begun, Bryan Pata, Eric Monker, and Dave Howell were returning to Eric Monker's dorm when they saw Rashaun Jones leaving Eric Monker's room. Bryan confronted Rashaun Jones to ask why he was in the room, and they got into a fistfight. That sounds mutual. They make it sound mutual in this. Bryan Pata got the best of Rashaun Jones, and after the two were separated, Rashaun Jones told Bryan Pata that he better clip up. During the fall of 2004, they never mentioned that he comes back, none of that. When Rashaun Jones was a freshman and Dave Howell lived in the Mahoney dorms, Dave Howell and Rashaun Jones began slapboxing. They were initially laughing, but one slap by Dave Howell got Rashaun Jones in the chin, and Rashaun Jones told Dave Howell that he had something for him. Rashaun Jones returned a few minutes later and pointed a gun at his face. Dave Howell remembers that the gun was a small black revolver. Dave Howell had never had a gun pointed at him before. We don't get any mention of Westerns here. During the fall of 2005, with a footnote, Dave Howell believes it may have been November 2005. Dave Howell and Rashaun Jones got into a fight inside the locker room over Dave Howell's girlfriend. At some point, Bryan Pata also became involved in the fight. Following the fight, Rashaun Jones was overheard on the phone telling someone, "They tried me and we're going to have to clip up." So they were overheard on the phone? Because, hold on, his testimony was that he saw him, he was called. Dave Howell said he was called, that the coaches needed to speak with him about his behavior. And that when he was leaving that meeting, coming back to the locker room, that Rashaun Jones happens to also be coming in the locker room, and he made it seem like something dramatic was about to happen. But all he described was Rashaun Jones going to his locker, and it seemed like he had a phone in his hand and was grabbing his bag and both of them, and he leaves. So he did mention a phone during his testimony, but only in that capacity. The words that were relayed are because Dave Howell sees a female athlete and is like, "Hey girl, come here. Can you go outside and go like ask this guy and see what he says and come back and tell me what he says?" So how do we get this story? When the state's asked to expand on the details, they come back and fill this in. So this information could only have been gotten from the underlying witness, Dave Howell. How is he? I overheard him on the phone saying that they tried me and we're going to have to clip up. During the summer of 2006, we got a footnote. Edwin Pata does not remember exactly when the conversation occurred, only that he was home from college and it occurred while they were in the bathroom of their home because he was showering and Bryan came in to take a dump when he came in and also decided to tell him this. Oh my goodness. What a level of comfortability. So during the summer of 2006, when Edwin Pata was home from college, Bryan and Edwin Pata had a talk about people on the team bothering Bryan. The one person Bryan mentioned was Rashaun Jones, whom he had previously mentioned to Edwin as someone he had problems with. Bryan told Edwin that Rashaun Jones had threatened to burn him in the head. Both Edwin and Bryan understood this to mean that Rashaun Jones was threatening to shoot him in the head. Bryan indicated that this threat was made after a confrontation with Rashaun Jones' parking decal. Edwin Pata encouraged his brother to tell the coaches about the threats. Edwin Pata followed up with Bryan in the September 2006 and asked if he had told the coaches about the threats, to which Bryan said he did not. Also during the summer of 2006, Bryan mentioned to his brother Edric Pata that he had gotten in a fight with Rashaun Jones and Rashaun Jones had threatened to kill him. Bryan didn't seem to take the threat seriously, but did tell Edric Pata about the threat at the time. Bryan also told his brother Fednal Pierre Pata about the threats made by Rashaun Jones. Fednal knows that the threats happened in 2006 and likely in the fall of 2006 when Bryan became unstoppable on the field after switching positions. Fednal requires Bryan telling him that Rashaun threatened to have him in his draft suit dead. The present case occurred on November 6, 2006. On the day of the homicide, the defendant Rashaun Jones had been suspended from the football team and did not attend afternoon practice. After practice, Bryan Pata returned to his apartment at the Colony apartment complex where he was shot in the head. During the autopsy, the medical examiner, Dr. Liu, recovered a .38 caliber projectile from Bryan Pata's head. And I have so many questions about this because if we're hearing that the family was pressuring and going to ESPN and pressuring the police to finally do something, that's a very big reason for this story to somehow be told that was never reported previously. In the instant motion, the state seeks to introduce relevant evidence through the testimony of witnesses who were either personally threatened or heard threats made by Rashaun towards Bryan Pata. The evidence is relevant, more highly probative than prejudicial, and importantly, will not be a feature of trial. Williams rule evidence is admissible when relevant to prove a material fact in issue, including, but not limited to, proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, but is inadmissible when the evidence is relevant solely to prove bad character or propensity. The linchpin of admissibility of evidence is relevance. And that's why it's so sus to me that the statements got more specific over time to match things that relate to the crime itself, because that gets over an admissibility hurdle, right? If you have this, oh, he said he's going to shoot him in the head. Well, he was shot in the head. It's relevant. It's more than just someone saying generally something that anybody might say. This was specific, so it's relevant. Or I'm going to burn you in your draft suit. Well, he was a football player, so it's got to be specific. It's more relevant. It's not just bad character. Like, it seems quite testimonial. And for it not to be reported contemporaneously or even earlier in time than when they were really trying to get this case prosecuted. Mavka still stuck on the dude's name being fentanyl. They did kind of say it like 3 syllables at the hearing. It was like fentanyl, the way they were pronouncing it. So, also, I miss SD Girl Sir. I didn't see her become a member, so I'm gonna have to say thank you to her tomorrow. I know she tuned out for the night. She had to go get on with her merry way because it is quite late. Sorry I missed this. Maybe she'll hear it on replay, but I'll catch her next time we see her. But yeah, all because they're scared ESPN will realize that they've been procrastinating. They continue here. They say the linchpin of admissibility is relevance. Any fact relevant to prove a fact in issue is admissible into evidence, even though it points to a separate crime, unless its admissibility is precluded by a specific rule of exclusion. What constitutes a fact in issue depends on the crime charged and the elements of that crime. And then they cite the statute for 404-2A and say it contains a non-exhaustive list of permissible purposes for the admission of Williams rule evidence, which includes demonstrating intent and encompasses negating affirmative defenses, such as accident, mistake, and lack of knowledge. When these types of defenses are raised, Florida courts have consistently allowed the state to admit evidence concerning prior criminal activity in order to refute them. The prior threats made by the defendant demonstrate the defendant's motive and intent to shoot the victim. In a different case, Reagan v. State, the court admitted evidence of 2 homicides in which the defendant used the same gun to shoot the victim in that case. The 3rd District Court of Appeals upheld the admission of the Williams rule evidence in proving the identity of the perpetrator. So same gun, but they had the gun recovered then, right? I mean, I don't really think that's the same as somebody thinking somebody had a revolver. Because they didn't find the weapon, the actual weapon in this case. So it doesn't really seem the same, but okay. The Reagan court went on to state that the trial court has broad discretion in determining not only the relevance of evidence, but also whether its probative value is substantially outweighed by the danger of unfair prejudice, thereby rendering such evidence inadmissible. The admissibility of collateral crime evidence is within the discretion of the trial court, and the trial court's ruling shall not be disturbed upon review, absent an abuse of that discretion. And we've got in Vargas v. State from the 4th District Court of Appeals, The 4th District Court of Appeal upheld evidence of prior threats made by the defendant, even if the threats were remote in time to the homicide. The Vargas Court relied upon the reasoning of the Florida Supreme Court in Lamb v. State, where the court expressed that the remoteness of the threat should go to the weight of the testimony and not the admissibility. I think this is a long-standing case. I mean, I think I've seen this case cited in Courtney Clenny motions and also Alicia Andrews in her motions recently. I think because of the admissibility of, for Alicia Andrews in the Julio Fulio trial, like a 3-year-old text where she said he needs to die in relation to Julio Fulio. I believe this must be like the centerpiece Florida case law on this type of thing for threats that are like far away in time compared to when the crime actually occurs. But the state here says that the state respectfully submits that evidence of collateral crimes listed in the state's Williams Rule Notice is relevant and that it's admissible. So signed off by the state attorney's office. So they're arguing why it should come in. It should come in, even though we have a motion to strike. So then we have notice of appearance here. Well, that's interesting. Didn't we have the notice of appearance already? Why are we repeating them? I don't know why this is... We saw her notice of appearance earlier, right? Yeah, so February 2025 notice of appearance. So that's kind of odd. Who knows? And I think we've seen all 3 of these names with notice of appearance, but for whatever reason, there's more on July 24th. Got depositions. They can incur costs for an electronic expert witness. Oh, is this going to be a phone guy? Let's see who our phone person is. John Sawicki. Maybe it's Savicki. A forensic computer scientist previously appointed in this case by order of this court in 2021 to assist with trial prep, including but not limited to review and analysis of cell phone tower data, computer and mobile devices, forensics, and rebuttal of the state's electronic evidence expert, disclosed on July 8th, 2025. So there we go. Let's see. Motion 2 for state's motion to determine the temporary confidentiality of court records. What do they want? They want to seal the testimony of Paul Connor. Do you think it's sus? That's specifically what we want to put under seal. We want to temporarily seal it. It's a state. They say, pursuant to Rule 2.42043, and we respectfully move this court to determine confidentiality of court records. They say, trial was scheduled to commence on October 6th at this point. This is being filed July 28th. Paul Connor is listed as a state witness. His testimony is essential. He identified the defendant in a lineup. On September 3rd, the state filed a motion to perpetuate testimony of Mr. Connor. The court granted the motion, and pursuant to stipulation by both parties, Mr. Connor's testimony was perpetuated during an Arthur hearing that took place from February 28th through March 2nd, 2022. At the trial of this matter, the state would have called Mr. Connor for the exact same testimony. The court granted the state's motion to admit the perpetuated testimony of Paul Connor on July 23rd, 2025. At this time, the state is requesting that the court temporarily seal the testimony of Paul Connor until it's admitted at trial. They say it's in the interest of justice and in fairness to both the state and defense. The state is requesting that this court seal the testimony of Paul Connor until such time as the testimony is admitted into evidence at the trial. So is this the stipulation? Like, since it was going to be ruled coming in, did the defense say, well, can we at least seal it? Maybe the state's making the request, but that was part of the agreement. I don't know. If Paul Connor's testimony is released or published in the media, it may affect both the state and the defense's ability to select a fair and impartial jury, as well as compromise the integrity of the trial. The state's request is not broader than necessary to protect the interests set forth above, and no less restrictive measures are available to protect the interests set forth above. So now I want to really watch his video when it's played during the trial and tune in and see, why are we stealing that? Why are we stealing that? I don't know. I don't know. Shout out to getting new stuff. That's awesome, that guy, Nick. That's awesome. You said you're full of yourself now. Oh, let's see. We've got depositions. We've got... Oh, wait, is this deposition available? This one has a file. All right, so whoever... Bradley Parks Boyd. His deposition transcript's uploaded here for whatever reason. Who is he? He's a Miami-Dade police officer. He's retired. He retired in 2011. Started in 1986. Dang. Let's see. Let's get to the relevant stuff. Okay, so he worked with Detective Dominguez. Okay. Dominguez, in this particular case, as a matter of fact, he came to me somewhere towards, I guess, and it says unintelligible, before this homicide, I have to look at the records, is when he came to my squad. But yeah, for the most part, a lot of the guys will stay assigned to the sergeant that they have for quite a while. It just depends on some other opening movements that they might want to work out. And in Detective Dominguez, stay on your squad throughout the rest of the time. No, this case was end of 06, November of 06, and by June of 07, he was on Pete Andrews' squad, I believe. He was no longer on mine. So at that point, yeah, my involvement was no more on the Pata case, being involved with it. And that was when in 2007, I'm sorry. I believe June. Okay, so you were a sergeant. There were some squads that were specialized, like, for example, the cold case. Yes. Were you part of any specialized squad at the time? No, I just had a regular investigative squad. Okay, any military experience? No. Are you testifying from a private place right now, so no one's within earshot of you? Yes, my house. Before we went on the record, did you have an opportunity to review discovery? Yeah, I read Sal Garofalo's report and Detective Dominguez's report. Okay, do you have an independent recollection of your involvement in this case? A fair independent recollection, yeah. It was a high-profile case, so I do have, certain memory issues of it. Okay, and did reading Detective Garofalo and Detective Dominguez's report refresh your recollection about whatever your involvement was? Yes, it did. All right, I know, again, of course, it's been a very long time. So if at any time you need to refer to the report, that's totally fine. Just let me know you're doing it so that we have it on the record. Sure. Did you write any reports? No, I did not. Did you deal with any evidence? And when I say deal with any evidence, I mean investigate any physical evidence like DNA, fingerprints, anything like that. No, I would have been present during certain portions when collection of evidence was recovered or collected. I think this is supposed to be transcribed as wouldn't have been, but it's mistranscribed. He says, I was aware of the results later on through police reports. When you say if I prepared any reports, I, obviously being the supervisor, I completed the internal memoranda to the chain of command in that regard, listing different details or facts of whatever updates were made. Do you know when you completed that? Well, our protocol was whenever we picked up a new case. By the end of my shift, I had that memorandum completed. And it's basically just an information thing, usually 2 pages, that consists of the day, the time, the occurrence, who the victim is, who the lead detective is, crime scene, doctor that responded, state attorneys that were notified, and then a brief synopsis of the event. And that's just from the night that it was assigned. Well, that was one of them. I'm sure there's other additional follow-ups that I did. I don't have those. I have a couple memorandums that I completed on that. Okay, did you speak to any civilians in this case? Yes. Which civilians were those? One was the information received from a man that lived in the apartment complex. I was put in touch with him through my lieutenant, Joe Lopez, at the time. He received a phone call from this individual. His first name is Jamie. Just bear with me. Jamie Duarte. He lived in the complex, and I reached out to him. And so we'll go into each of the civilian statements to you a little bit more, but just tell me a list of who all the civilians that you spoke with were. There was a young man that purchased a car from Pata up in Arkansas. I have to look at these. And then the question's unintelligible. And then the answer to whatever it was yes. That sounds familiar from the notes that I made from Dominguez's report. I believe that was the name. Question. And that was with Detective Garofalo that you traveled to Arkansas? Yes, that's correct. Okay, and who else? Let's see. These are just some notes that I had made that I'm looking at from Dominguez's report of my involvement, my specific involvement. So let's see. And let me ask, do you have Detective Hellman report handy as well? I do not. Okay, would you like a copy of that sent to you in order to reference during this deposition if you need to refresh your recollection? Yeah, I mean, how long it is. I could take some time to review. Do you remember traveling to Boston to interview Jerome Brody? Okay, so this is twin brother of Jada Brody, who was dating Bryan Pata at the time of his shooting. And he says absolutely yes, he remembers that. Okay, do you feel like you need anything to refresh your memory about that? No, I have a pretty good recollection of what took place. At least the main investigator from their homicide bureau in Boston, which is Paul McLaughlin. Okay, so that was my bigger concern with Hellman's report, I think. That's when the details that a little bit more than Detective Dominguez is. But if you remember, then... And he says, yeah, let's see where it goes, and if there's something that you're asking more specific that I can't answer, well, I'll let you know. And the question says, sounds good. Okay, so we have... And then it's unintelligible. This is, going back to Arkansas. This is the answer now, because the question got cut off. I had contact with Jones' stepfather, Rick Randall, not a Rick Roll, and his mother, Dora Randall. Let's see. After the Arkansas trip, Sal Garofalo and we went to Clemson University and spoke with a man there named Sadat Chambers, who was a friend of Jada Brody. And then Jada Brody was actually transferred up to Clemson for her studies. And so she was interviewed up there, and during these interviews, Sal Garofalo was mainly conducting the questioning of those. But I was present during the answers of these individuals. And do you remember do you have a recollection of that? He says, reviewing these two reports, I do, yes. Okay, other than what's in those reports, does anything else come to mind? No. Well, let me ask, were any of these recorded? No, they were not. They were just interviews that were handwritten by Sal. Interviews, and when you say handwritten, you mean contemporaneous notes were taken? Do we have those notes? He says, yes, that's correct. Question, did you take any contemporaneous notes? At the time, I may have. I don't... again, since I left and cleaning up everything, I don't know where any of those would be right now. Okay, all right. So, other than that interview that you just referenced in Clemson, you went to see Sadat Chambers and you went to see Jada Brody. Yep. And then from there, well, prior to that, I spoke with Dominguez. I went with Dominguez out to Los Angeles and spoke where Willie Williams was interviewed. Willie Williams is guy at club when there's this Haitian gang fight and like stuff was being thrown, and Willie Williams says he gets a call from a number after this fight saying that there's a hit on him and Bryan Pata. According to Willie Williams was also roommates with Eric Moncur, who is where this dorm fight happened between Bryan and Rashaun Jones. So Willie Williams, very interesting name. I'm sure Mavka is excited in the chat. So, Tatum says yes, so no notes. And then we've got, they interview Willie Williams in Los Angeles, and then they go off to Oregon for another former player or associate of Pata's. His name was Howell, last name Howell. I think that's Dave. And then during that trip, when we were in LA, we got notified of the Boston information on Jada Brody's brother. How common is it to travel to all these different cases and investigate a homicide? It depends on the circumstances. I mean, obviously a high-profile case like this, you've got a lot of scrutiny, from not just the media, but the university itself. It's not uncommon for the department to expend monies to send detectives to various portions of the country to do interviews. And it happened quite a bit. I mean, even when I was at the robbery bureau, I can't tell you how many countless times I went to New York City for cases, just to either go interview victims or locate subjects. Sounds fun. I didn't know that was a perk of the job. You get to travel all these different cities. We went to LA, we went to New York City a few times. We're traveling to different parts of wherever Paul Connor is moving to and living at that given time. Nice little job perk. He says, all right, so why don't we start with, well, actually, before we go into the interview, other than those interviews, what other involvement did you have in the case? There was a case, the name was Andy Trujillo. He was in Colorado Springs. He had notified our office about a potential lead. So I followed up on that, and then the person he was referring the information about, an Angie Adams, I believe was her name, and I made contact with her. Question is, what was that about? Andy Trujillo called the Homicide Bureau. I spoke with him on at least 2 or 3 occasions, and he was claiming that an associate he had contact with out there in Colorado Springs, Angie Adams, had made statements that she was involved in the homicide of Bryan Pata. What? And had information on the gun that was used. Who the heck is Angie? And had information on the gun that was used. And so, of course, anytime you get information like that, you take a step further and start researching and looking into it. And what did you find when you researched and looked into it? Well, it turns out Mr. Trujillo was involved in the drug scene out in Colorado, and both he and Angie were drug addicts. Miss Alvarez says, this is attorney for Rashaun Jones. I'm sorry, give me 1 second. I think we have another witness who just joined the Zoom. I just want to make sure that... And the court reporter says, I can put him in the waiting room, but it looks like he's not scheduled until 1. Miss Alvarez says, right. Maybe I think he's just early. If you could put him in the waiting room, I just don't want him to hear the testimony. Thank you. Good eye. So Miss Alvarez continues questioning. Okay, I'm sorry. Go ahead. So Andy Trujillo and Angie Adams knew each other through the drug scene. They were both doing drugs, and he claimed that Angie was dealing in drugs for a particular dealer out there. This was right at the beginning of February of 2007 when these phone calls took place. And these individuals, you said they lived in Colorado Springs? Yeah, in Arvada, Colorado. I guess it's like a suburb in between Denver and Colorado Springs. And how did they know Mr. Pata? He claims that Angie Adams, in the course of doing drugs with her, made a confession to him that she was involved in a murder of a football player and called him Pata. P-A-D-A. Is what Trujillo gave the spelling of. Did he tell you how she indicated that she even knew him? No. And what happened when you followed up with that? Well, I was trying to get more specific information as to who Angie Adams was and where she was at out there, location-wise, address. And then I reached out to police. And that particular jurisdiction is Colorado Springs in Arvada, and asked them to keep an eye out for her, do research if they had such an individual, as well as Andy Trujillo. It's basically at that point I was still waiting to see what information I could uncover before even going out there. Did you ever go out there? Yeah, I did. I went out to Colorado Springs, and with the help of some of their homicide detectives, located Andy Trujillo and brought him back to their office and did an interview with him. Which homicide detective was that? His name was Derek Graham. Tell me about that interview. Basically, going over the previous information he'd given me on Angie Adams, asking him, more specific questions. He was coming up with dates of having contact with Angie in January, from early part of January to the later stages of January. But he still didn't have an address for her. And while I was out there, he was never able to locate her in that state. And did he specify what she had said her involvement had been? Yeah. She may have taken some money off of him. He said that, according to her client, she took some money off him and shot him and then fled, but nothing more specific. He claimed, was there reward money for information or something? He claimed that she showed him a photograph of her and Pata together and also showed her a gun. I'm sorry. He said that she took money off of Pata, shot him, and fled. Yes. And he claims that she showed him a photograph of her and Pata and also a gun. Yes. Okay, what efforts were made to locate her? I did criminal history checks on her. She did have a connection to Florida, and as a matter of fact, after the result of not being able to find her in Colorado, I was able to find out that she had a child enrolled in the school system in Dade County in the Homestead area. And so I was actually able to eventually speak with her. This is the whole thing with what the information Trujillo was providing was no longer, I guess, valid from that standpoint. She had records indicating when she came back to Florida. It was before any of these dates that Trujillo provided me when he was with her in January of that year. She was back in Florida, I think late December, mid-December of 07. Would it have been possible for her to have been going back and forth? No, she and her child, they took a Greyhound bus. That's how they were getting around. She's not a wealthy woman. She didn't have the means, the monetary means, to have a vehicle and go back and forth like that. Do you know where she was on November 7th of 2006? At that time, she was out in Colorado because she'd just come back in December to the state of Florida. Well, do you know? So the question is, do you definitively know where she was on November 7th, 2006? Do you have any hard evidence other than what she said, assumptions that can be made based on when she moved from point A to point B? And then he says, I would have to see if there's any other records out there. So that's a no. I know that there were computer records generated trying to find out who she was and where she was at. There's a possibility that it's there. But right now, at this moment, I couldn't tell you. I will say the Colorado Springs detectives informed me about Trujillo, and this is the part. They've known Trujillo at that time at least a year and a half, and they were aware that he had reached out to Washington State police detectives somewhere and trying to claim that he had knowledge of a homicide that occurred there, which, according to the Colorado Springs detectives, did not take place. He also provided Colorado Springs detectives with the shooting and a homicide there, and that didn't pan out. They were able to disprove his knowledge of that. So Mr. Trujillo wasn't batting 1,000% on the accuracy. Why is he doing this, though? Was there a reward or no? Was there a reward? So Miss Alvarez says, okay, so he has some credibility issues. And the retired officer says, yes, very much so. So with respect to the photos that he says that he saw, did you ever ask Angie about that? Yes, she says she didn't know Bryan Pata, had no knowledge of him, never knew him in her life, and there's no indication that she did. She's an older woman, and when I say older woman, she was, at the time, had to be in her early to mid-40s. So that's probably at least 20 years older than Bryan Pata. Okay, and so I don't believe I have seen this in reports, and I know you didn't author a report. Did you give this information to Detective Dominguez? Yes. Okay, I may have missed it in his report. And she says it's quite lengthy, but... And then he says it could have been glossed over because of the fact that there was no proof or, the alibi of Angie Adams checked out in that regard to eliminate her and eliminate the information provided by Trujillo. And then the question is, but what exactly was her alibi that she... And the answer, just that she was out in Colorado Springs. I would have to look at the police reports. I want to say that their police records, they knew who Angie Adams was because they had contact with her when she was out there because of her drug issues. So I want to say the knowledge that I had at the time would be that there was some type of police report documenting her presence when she was out there during the time frame of the murder. Okay, but without having that report, you can't say with certainty whether that existed or whether that was what ultimately ruled her out for you. No. All right, so other than these individuals, and other than the civilians you've mentioned, which are Jamie Duarte, Chris Jones, Sadat Chambers, Jada Brody, Willie Williams, Dave Howell, and Jerome Brody, was there anyone else that you spoke with? Or anything else that you did to investigate this case? No, not that I'm aware of. Nothing that stands out. Like I said, I was present for these interviews. But these interviews, again, like Williams and Howell, Dominguez was the lead detective. I was with Dominguez when these interviews took place, but he was the one mainly doing the question and document it. Okay, so I just want to ask you a little bit more about a few of these interviews. Okay. What did you learn, or rather, when did you speak with Jamie Duarte, and what did you learn? That was about 3 or 4 weeks after the homicide when I was put in touch with him through the lieutenant that I told you about. And so that was just a phone conversation I had with Mr. Duarte. And can you tell me about that conversation? Well, he indicated on the day of the murder, he saw a suspicious car driving in and out of the apartment complex. Took notice of it. He works from the house and was looking out the window as he was on the computer. And that's what brought his attention to it. So he noticed the car. Did he mention what kind of car it was? So it was a gray vehicle, just a regular passenger car. He didn't think anything more of it. And then what? He said he went to pick up his wife, I believe at South Miami Hospital. When he came, I believe he left, he saw the car parked out on the street somewhere in the immediate area of the apartment complex. So he took notice of that. Somewhere over the course of getting his wife back home, he thought it was important to write the tag number down on the car. That's how we came up with the tag number on this vehicle. So this was a vehicle that he had seen in the area going in and out. He thought that there was something suspicious about it, so he wrote the tag down. That was before there was ever any homicide? I believe so, yes. Did he indicate what time he went to go pick up his wife? I couldn't tell you, and then it's unintelligible. And when he got back, was the vehicle still there? No, it was not. If I recall correctly, the conversation that we had, no. And where did he see the vehicle in relation to where Mr. Pata was killed? Right there on the avenue of the apartment complex. Like right around the corner? I believe so, yeah. And what steps were taken to investigate that vehicle? Well, the information, once I received it from Mr. Duarte, we did a tag check on the car to see if it was registered anywhere close to the area. Comes back, I believe on a BMW, and the registered owner was up in West Palm Beach, an older gentleman. Did you do anything to investigate that? No. The information is provided to Dominguez, and I believe he delegated that lead to be followed up by another detective, possibly Detective Diaz, Pat Diaz. Okay. Any other further information about Jamie Duarte? No. All right. What about your conversation with Jada Brody? Tell me about that. So present at the Clemson location, and Garofalo just queried her about her relationship with Pata and if she had any further knowledge. Anybody reached out to her concerning who shot and killed her boyfriend. What did she say? She denied having any other knowledge about it. That interview, from what I recall, was very brief with Jada. She really didn't provide anywhere near as much information as to the relationship that she gave earlier in the investigation, I believe, to Dominguez. When was this interview? At Clemson, that would have been around the time that we went to Arkansas to follow up with Jones, who brought this car from Bryan Pata. So there's another Jones in all of this. Was she asked about anything that was going on in Bryan's life? Any threats that were made or being made against him? Anyone who would want to hurt him? She made some comment about someone confronting Bryan on the phone about stolen items, stolen rims for the vehicles that he was selling. But as far as that, I believe that was somewhere along the line. That lead was eliminated as being a motive for the homicide. That should have been in Dominguez's report, I believe. I saw it somewhere in his police report. Okay, but you don't know if it was actually eliminated, do you? I believe so, yeah. And then unintelligible. So probably like, how do you know? And then the answer is, because I know that the rim issue was followed up on, and what I recall before Dominguez left my squad, we were no longer following up on the tire rim issue, and I believe they located the individuals who had knowledge of these rims. And again, reviewing Dominguez's report, it was listed in there somewhere as to that lead not being viable as part of the motive. Question. Fair to say that you don't personally know if it was eliminated, why it was eliminated? No. Not fair to say, or fair to say? I can't tell you why it was eliminated unless there's something out there that would refresh my recollection from another report. But no, I don't recall. Was Jada asked about her family's relationship with Mr. Pata? I believe so. I know there came a point where her father was in prison in Massachusetts. I know the interview was followed up on when we were in Boston again, at the state prison. She says, okay, so why don't we go to Boston? He says, I'm sorry? She says, why don't we go to Boston? So, did you go from Clemson to Boston? No. Actually, when the Boston, Los Angeles, and Oregon trips were in December of 2006. Those occurred before we even went to Arkansas and Clemson. Oh, so you went to kind of investigate Jada's family before you went and spoke with Jada in Clemson? Yeah, yep. There was obviously any type of homicide investigation. You want to know the relationships of the parties involved. So, yeah, there's always reasons you want to address and look into. Always issues you want to address and look into. So they don't follow up with Jada before they go speak to all these other people. So anyway, she says, yeah, so why did you go to Boston in December of 2006? Well, we got a phone call from a Boston police officer, and they were aware seeing the news reports of the murder of Bryan Pata and knew that his girlfriend was possibly related to somebody that they just arrested. What did they tell you about that individual? Well, he was caught in a car fleeing from the police with two other individuals. And when they apprehended him at the conclusion of that, they located some guns in the door panel of the car, identified the passengers, one of them being Jada Brody's brother, who had a pretty good criminal background in Boston. So that's basically how they made a connection that we might have an interest as to who this individual was. And before you went up there, did you learn anything about the relationship between Bryan Pata and Jada's family? Possibly that Bryan Pata may have been verbally threatened to watch his back by the father of Jada, and that was one of the reasons why he was interviewed at the Massachusetts prison. What was the father's name? His last name was Gaines. Gary Gaines? Possibly, yes. And so he was locked up, you went there, he was in prison. Yeah, I believe he violated his parole after being released not too long before he had a pretty substantial criminal past like his son. And so when you interviewed him, what did you ask him and what did he tell you? I didn't ask him any. I was there with Dominguez. And I believe Hellman was there and as well when we were in the interview room. But just basically querying him if he had any contact with Bryan, had any issues with Bryan. And from what he indicated, he had not. Did he indicate whether any other family members had issues with Bryan? No. He said his son, he was aware we were up there to talk with his son, and that his son had recently been arrested. He threw out the comment that if his son knew about Jada was threatened or, been hurt by somebody, his son would take action to address it, even to the point of using violence. Did he specify the kind of action, the kind of violence? No, just he indicated that Jada had a sexual battery in her background, being hurt by somebody, a family acquaintance, I guess. And so her brother would always be overprotective if he felt his sister was threatened. And were you able to speak with the brother, Jerome? Yeah, well, the young man that was arrested by Boston, we went to the jail where he was incarcerated at. Tried to have contact with him to do an interview. But from the very beginning, once he knew who we were and why we were there, he just was very arrogant and didn't want to cooperate at all. So there was no interview with him. Tell me about that. How did the communication break down? I know he was difficult, but how did you try to get through to him and what did he say? He's very combative. We identified, we told him we just wanted to ask him some questions about his sister and her relationship with Bryan. He didn't want to have any part of us. Did you ever ask him or did you ever have the opportunity to ask him if he was involved in the murder? No, he kept shutting us down. He was yelling, he was screaming, he was making a scene in the jail. So it's like, it wasn't conducive to ask him any specific questions. Do you know if he was interviewed by anyone else at any time? Not that I'm aware of, no. Do you know if he was in custody at the time of the murder? I can't say. I do know there was something there to indicate to us that he was in Boston. There was, if I remember right, his cell phone records put him in Boston during the time of the murder. Also, the firearm, one of the firearms that were particularly interesting, that we're particularly interested in, was a .38 caliber revolver that was found in the car, and it was a Rossi, and that was one of the possible makes of the firearms that could have been used in the homicide. So we definitely had a keen interest in that. And I know we took back several projectiles and we test fired it through the lab at the Boston Police Crime Lab, and those were taken back down to Miami for forensic analysis. Do you know the result of that forensic analysis? Yeah, it didn't match up. But fair to say that Jerome Brody could have another firearm of the same make. Possibility. He could have had several firearms. I don't know. Not that I'm aware of, no. And with respect to the phone records, did you personally review those records? No, I can't say that I did. Do you know who did? It should be Dominguez. It should be Dominguez or whoever he assigned the lead for the phones. I don't know. Possibly it even could have been Hellman. I'm just speculating, though. Are you sure those phone records were pulled? Yeah, right at the beginning of the investigation, there were several subpoenas for cell phone records, and then it says unintelligible. And have all been made part of the case file? Yeah, there should be quite a substantial amount of phone records in there. Okay, so aside from Jerome and Mr. Gaines, did you speak with anybody else while you were in Boston? No. Any neighbors, any friends, any other family members? No, I did not. And what about... So now let's talk about Willie Williams. When was that interview? Well, that was done before going to Boston. And I think that was around the first week of December when we were out there, Dominguez and I. I think his report, I did see it in his report when we were out there. But I want to say December 7th, about a month after the homicide, I believe. And why did you go talk to Willie Williams? Just a background. He had possibly, well, he was supposedly at a nightclub where Bryan Pata, he and some other players had some type of fight or altercation with Haitian gang members. So obviously at the time, early on in the investigation, yeah, we're looking at that too, you know? Not just his relationship with Jada and her family, but, you know, these side issues with stolen crimes, stolen rims, the gang fights. We're going in all different types of directions, trying to control this as much as we can. But Willie Williams would be somebody of interest to go talk to about that, to see what other information he could give us. And Miss Alvarez says, and what other information did he give you? I probably have to refer to Dominguez's report here. Sure. Let's see if I can figure out whatever that was. Page 48. I believe it's got to be around page 48 of that report. Let's see. Okay, yeah, it's covered in the first paragraph on 48. Williams made a comment that Bryan had told him that he was approached by somebody at the USA flea market, accusing him of stealing rims off of a vehicle. So Bryan tells Williams. And so, of course, you know, he had information about that. He didn't know who that was, though, the person that was making those threats. What did he tell you about the Club Life fight? I believe on the Club Life, the players were inside, and it was, from what I remember, the description of the event was that it was really crowded. No room for any more people to come into the club itself. It was just jam-packed. And as usual with any bar fight starting, it's because somebody bumped into somebody else, and then it became physical to the point where it spilled out of the bar. And the police had to come and use pepper spray, according to Williams, and then separated everybody. That was the end of that involvement. Just that because some of these people they were fighting with, word was they were Haitian gang members. And I guess the information through the grapevine came back that they should watch their backs, that these gang members would come and take further action to hurt them. Willie was the one who told you that? I believe so, yes. And did he indicate that there were hits out for both him and for Bryan? I want to say Williams was concerned that, you know, one of the threats may have been directed at him in that regard, but I have no independent recollection of him being scared. He just wanted to go out to Los Angeles and change schools because he wanted to get back to concentrating on his football. Okay, did he tell you that he called Bryan and told him about a hit? I believe there was some mention, yeah, of a phone conversation that he informed Bryan about. And how long before Bryan's murder was this fight at the Club Life? That I don't know. It should be somewhere in Dominguez's report, or there should be information in the file to indicate when that incident was and when it took place. Okay, what about, did Willie Williams ever, well, before I go there, the Haitian gang members that was referenced, did you ever learn what that gang was? I did not. I don't know the name of the specific gang that was mentioned. No, I don't. Okay, and did Willie also indicate that Bryan used to date a lot of Haitian women? Yes. Again, I see that in Dominguez's report on page 49. It's a typical relationship, I guess, with the players there. They would be on good terms 1 minute, and then something goes wrong, they get in arguments, and have a brief breakup or whatever. Okay, and what about Dave Howell? Tell me about your interview with him. When was it? Where was it? That was in Portland. It would have been after this. We met with Williams first, and hold on, I do remember seeing this again in Dominguez's report with Howell. That one was very brief from what I remember. Oh, the Chatty Patty had a brief interview? He didn't have anything to add that would have been of interest to us or pertaining specifically to this case. What? Meanwhile, Dave Howell is where we get 3 of those bullet points for the Williams rule evidence. They come from Dave Howell. Mr. Chatty Patty with the longest, the 59-minute pretrial testimony that we watched in session 1, the longest of the 4 that we watched testify. Very brief, didn't have anything to add that would have been of interest to us or pertaining specifically to this case. Come on. And I don't know why this deposition's included, but I'm glad it is. Because it's like a little bit of each of the little seeds for the other names. Like, all right, so this guy, Chatty Patty, has nothing to say, Mr. Dave Howell. So Miss Alvarez says, did any of the individuals who you interviewed mention Rashaun Jones? No. I know that name came up through information that Lieutenant Hellman had provided. He'd done some interviews, I believe, with UM players at the Athletic Center. And then I think Pat Diaz may have provided some information as well. I know his name came up pretty quickly in the investigation, But again, we were looking at 4 or 5 different issues. Question. And so Jada Brody didn't bring up Rashaun to you? Not to me, no. And neither did Willie Williams or Dave Howell? No. Okay. Not that I'm aware of, no. Let's see. All right. We are running out of time, and I know I have back-to-back depositions today. Is there anything else that we have not discussed that you did in this case? Any knowledge that you have that you think would be valuable to tell me? No, if I come up specifically with the questionings you're asking me about the Colorado thing, if I find anything, I do have some stuff, but it's packed away, and I've been trying to find it. I just haven't been able to. So, possibility, it may have something there. I will continue to look through old files that I do have at the house. Okay, I appreciate that. And if you do find anything of value, will you please let me know and let the state attorney know before this case goes to trial? Absolutely, I will. And you understood all of my questions? Yes, I have. And have I given you an opportunity to answer all of my questions? Yes. And let me just turn it back over to the state in case she has any questions before we go off record. And then Miss Diamond says, I don't have any questions for Sergeant Boyd. And then they say, okay, thank you so much. We'll invoke your right to read. Thank you. All right. And then that is the conclusion of his deposition. So for whatever reason, we have all these depositions, but that one we get the, it's filed there on the record. So, this is the time. What do you guys think about that? These initial interviews, the order they're doing the interviews. I thought they did some type of thorough interview with the twin brother who started to get mad at some point, but that they had successfully done some question and A with him. And it seems like they didn't get anything. He was being petulant. And he was getting mad that they were talking to family members. I don't know. Is the family all good? Are all of the family members ruled out as suspects here? I feel like if we had like a Guess Who, like the game with all the little faces that you flip down, we'd have to pick them up. We'd have to bring some back to the table. Like, I don't know. I don't know. And then again, even if you try to go now and interview and follow up with things that were not followed up on, that's not like waiting a month or two or waiting a year or two, which is still a concerning amount of time. This is like over a decade's passing. Even if like 2016 there was some movement, 2020 there's some movement because of ESPN, that's still 14 years removed from when this happened. And now, by the end of this year, we'd be 20 years from when this happened. So to try to fill any gaps, things that we didn't follow up on back then, you're always going to have an issue because it's so far removed. It's 20 years later. People's memories degrade. Yeah. Is this all just AI? Mavka's like, I'm losing my mind. How did they not dig into Dave and Willie? And why he was such a chatty patty at that hearing. Mel says Team Willie, Chatty Patty, and the brother. Oh, man. Yeah, I mean, I agree, Mary. He'll be lucky to get out. I mean, and he's been in custody since 2021. He could post bail, I guess, for $500,000, but he's on Monday, I guess they might potentially hear, yeah, they're going to talk about some motions and some issues, and potentially bond could be raised again. Not raised in amount, but the issue of bond could be raised and maybe kick it down a notch. He's indigent and his bond, it's been reduced, but it's still at $500,000. So EJM says I'm still stuck on MySpace. Well, good news is the state doesn't have those subpoenas, and who knows what happened to them. That's not really part of this anymore. So yeah, he was granted after the mistrial. It was a higher amount at first. It was kicked down to $500,000. I think it was like 1 point something at first, but it was kicked down to $500,000. When we get to those motions, I'm sure they'll lay down procedurally. It was this and it was this, and now we're moving again. But it has been kicked down, and I think it's still a high amount. He's not posting it, so. Couldn't they scream he didn't get a speedy trial? I mean, I think that's why they were careful to say, again, this is all before the first trial happened, but when we read that recent motion for a continuance, that's why they were careful to say, can we charge it to the state? Like, these issues are because they haven't turned over their discovery. But once we get past the trial, there was a more recent hearing we talked about in the background info that we read through. The judge was freaking out on the defense because they filed motions after the deadline and was mad that they'd have to push the trial back. The trial was supposed to start this Monday, but now they're using that space for a hearing instead because the judge got pissed at the defense for filing motions past the deadline. But the thing is, the motions the defense was filing, it's stuff that they couldn't have raised earlier. It's new stuff that's coming in, new issues that are arising. So they filed it in a way that's timely to the relevant issues, but it was past the context independent deadline, and the judge got mad about it and chastised the state. So I feel like the judge's position now is it's the defense causing delays and not wanting this retrial. So that just is what it is. If we move forward in the docket here, we're getting close to 500. We've got motion to get some attendance of witnesses. It says Patricia, Mike Sand, Hamlet Castillo, Andrew Johnson. They set a sounding hearing because they were originally supposed to start trial on October 6th. Well, not originally, but at this point, the trial was October 6th. So in Florida, we do, I think it's like a 10-day sounding, 10 business days, 10 court days, 10 days before to make sure we are good to go for trial. So they set the date in August 8th for September 25th for a sounding for the October 6th trial, with a status hearing in a few days. We have a motion to withdraw, so one of the attorneys is pulling out. Okay, so this is Tyler Wood. He's motioning to withdraw. Yeah, Rashaun Jones consents to him withdrawing. Yeah, and this is the guy, at least his work, I don't know about the others, but his work on this case was pro bono. So Tyler Woods came up here. Some of the stuff that we read was written by him. And again, I wonder, some attorneys just do pro bono work in general. Like they'll find cases and they'll take it without like a real specific reason for doing it. But I do wonder if he heard this case and was like, what the heck? Let me get in on this because this is ridiculous. The guy's indigent. This looks like a hot mess. And came in maybe because he felt like some imperative that he had to come help. I don't know. Just wondering. All right. So then we've got, let's see, status hearings. They grant the request for the certificate for the out-of-state witnesses. Tyler Wood can withdraw. All right, so we have a memorandum of law in opposition to the state's William Rule notice and in support of exclusion. They're talking about the amended notice that added this bit and gave the additional context. Remember, that was the longer one where they start to give some of the dates. All right, so they say the notice is statutorily defective and should be stricken. The state must give written notice describing the alleged acts with the particularity required of an indictment or information. In this case, the state's Williams Rule notice fails to provide indictment level particularity and fails to specify time and place as definitely as possible. Item 1 gives a 9-month school year span and no location. Item 2 spans summer of 2004 or 2005. Item 3 is fall of 2005, which is a 3 to 4 month window. Item 4 gives no dates beyond the months leading up to the homicide and no location, and that these defects deprive the defense of a fair opportunity to investigate and prepare. Moreover, the statute requires the notice itself to supply the particulars. The state may not cure a defective Williams Rule notice with a subsequent memorandum of law. In this case, the state's notice is statutorily defective and the court should strike it in full, which they're not going to. Because we end up, when is it filed? August, whatever? Because the hearing was like the 21st or 22nd or something. So we know that that's not granted. And then they argue that the state cannot prove these collateral acts by clear and convincing evidence because it's vague and shifting timelines. It's uncertain. And then notice items 1 through 3. They're dissimilar, generic, remote, and do not prove material disputed facts. So they say, assuming arguendo that the state can prove the collateral acts by clear and convincing evidence, collateral act evidence is only admissible if it's relevant to prove a material issue that is genuinely in dispute. The state argues that the collateral acts alleged in items 1 through 3 are relevant to prove intent and or identity. However, neither Bryan Pata's nor Rashaun Jones' state of mind are material issues genuinely in dispute in this case. Mr. Jones has not raised a theory of defense that would make state of mind relevant, such as accident or self-defense. When intent is not a material fact or essential element of the claim, the evidence cannot be admitted when it is offered for the purpose, since any probative value would substantially outweigh the danger of unfair prejudice. And then let's see. Since intent is not genuinely in dispute in the instant case, using items 1 to 3 to prove intent would allow the state to put forth unreliable, impermissible propensity evidence in circumvention of the rules of evidence. To prove identity through other acts, the state must show identifiable points of similarity with unusual distinctive features or a signature modus operandi, or MO. The collateral acts alleged herein, like the generic dorm and locker room fights of 2004 to 2005, some of which Bryan Pata was not even involved in. Yeah, because they said he was present in the locker room, but not really for any of the phone call stuff or whatever happened. And the slang phrase, clip up, do not involve unusual markers tying Mr. Jones to a later November 2006 homicide in the parking lot of an apartment complex, the facts and circumstances surrounding which are almost entirely unknown. In addition, these alleged events are remote in time, and as the state concedes, the specific dates are uncertain. So they said that Dave Howell believes it may have been in November 2005. Edwin Pata does not remember exactly when. The uncertainty and remoteness of these alleged events further erodes their purported probative value. Then we've got notice item 4. It's inadmissible hearsay, unreliable, and does not prove material disputed facts. So this is the 3 brothers coming in and saying that they heard that Bryan told each of them about, I'm going to put you in your draft suit, burn you in your draft suit. So item 4 is inadmissible double hearsay. Bryan Pata's out-of-court statements offered for the truth of the matter asserted that Mr. Jones made threatening statements. The Williams rule does not create an exception to the rule against hearsay. Admission of collateral act evidence must comply with the evidence code. The state concedes the hearsay nature of these alleged threats, vagueness and timing, and the fact that Bryan Pata never reported these alleged threats to the police, the University of Miami, or his coaches, and didn't seem to take the threat seriously. Additionally, item 4 is particularly unclear as to when the statements were allegedly made and to whom. Yeah, the greatest clarity is just that we have from the one brother, I was showering and Bryan came in to take a dump. It was after he came home from the school year. We were home from school. And he came in to take a dump. And that's when he told me this. Additionally, item 4 is particularly unclear. Moreover, as previously stated, Williams rule evidence is admissible only if it's relevant to prove a material issue that is actually disputed in this case. See defendant's memorandum of law, and they cited all that law in the initial memorandum. As the threats alleged in item 4 are not relevant to any material issue that is genuinely in dispute in the case, this collateral act evidence is inadmissible. And then there's a balancing test. So relevancy is only one of the issues. So if you determine that it is relevant, you then must decide if the probative value to show motive, intent, preparation, or plan, knowledge, identity, or absence of mistake or accident outweighs any unfair prejudice, confusion of the issues, all the 403 stuff, misleading of the jury, or needless presentation of cumulative evidence. Even if the court were to find that any of these alleged collateral acts are marginally relevant, their unfairly prejudicial effect would substantially outweigh any de minimis probative value. Further, allowing the state to introduce the proffered testimony would inevitably result in a series of mini-trials regarding these uncharged allegations, creating a scenario where the alleged collateral acts become the feature of the trial, a result that the Florida Supreme Court forbids. Oh, that's interesting. A lot of cases on this one. They cite a bunch of cases on that issue. And then in conclusion, Because the state's notice fails to satisfy the particularity requirement, and the proffered acts are layered in hearsay, remote, generic, and unduly prejudicial, the court should strike the notice, exclude the evidence, and bar the state from offering collateral acts evidence at trial. So wherefore, Mr. Jones respectfully requests that the court grant the defense's motion to strike and or exclude the proffered Williams Rule evidence set forth in the state's Williams Rule notice as amended. So they say strike it all, then get rid of it. All 4 of the things. Exclude it. It should not come in. Let's see. Oh, is there more? Okay, there's another memorandum of law from the defense, it looks like. Oh, this is the case law, I think. Let's see. Oh, this is after the hearing. Oh, so they're gonna eat up everything that happened at the hearing. All right, so they say for Eric Monker. First, the state called Eric, one of Bryan Pata's best friends at the University of Miami, to testify with respect to a confrontation in his dorm room. According to Mr. Monker, this confrontation occurred in the summer of 2005, with a note here that according to David Howell, the confrontation occurred in the summer of 2004. Mr. Monker stated that on the night in question, he and Bryan Pata arrived at his dorm and found that the door to Mr. Monker's room was locked. After briefly going upstairs to Mr. Howell's room, Mr. Monker, Mr. Pata, and Mr. Howell returned to Mr. Monker's dorm and encountered Mr. Jones in the hallway. The 4 boys all went to Eric's room, where Eric, Mr. Pata, and Mr. Howell confronted Mr. Jones for being in the room when Eric was not there. Although Eric did not believe this to be a big deal, Mr. Pata was not satisfied with Mr. Jones' explanation and became very upset. When Mr. Jones tried to exit the room, Mr. Pata precluded him from leaving and instead pushed Mr. Jones onto the bed, punched him, and then got on top of him and began to headbutt him several times. Mr. Monker was able to pull Mr. Pata off of Mr. Jones, allowing Mr. Jones to get away. According to Mr. Monker, as Mr. Jones walked out of the room, he stated, "You might as well clip up." Mr. Monker testified that he understood this phrase to mean, "get your gun," and that the meaning of this phrase was common knowledge. Mr. Monker further testified that he had never seen Mr. Jones with a firearm, never heard Mr. Jones say that he had a firearm, and never heard of Mr. Jones pointing a gun at anyone. Mr. Monker stated that he did not believe anyone was going to actually shoot anyone over this incident, and acknowledged that fights among players on the football team were not uncommon, although they usually occurred in the locker room. Significantly, Mr. Monker testified that he was not aware of any altercations between Mr. Pata and Mr. Jones prior to this dorm room confrontation, or at any time thereafter, and neither Mr. Pata nor Mr. Jones ever brought this incident up again. Then we've got Mr. Howell. We've got the chatty patty. So next we've got I was looking over here. Yeah, I don't know either. I also don't understand why they charged him with second degree if they believed he walked and shot him in the head. And we've heard that state seems to think that they were hiding behind the dumpster, hiding in the bushes, waiting for him to come home. That's, a plan. That's a plan. So I also don't know. So we've got, let's see, the state calls David Howell, another one of Mr. Pata's best friends, to testify about the confrontation that occurred in Mr. Monker's dorm room. According to Mr. Howell, this incident took place in the summer of 2004. Mr. Howell testified that he and Mr. Pata blocked the doorway as Mr. Jones tried to exit the room, at which time Mr. Pata grabbed Mr. Jones and began punching him. Mr. Pata and Mr. Jones ended up on the bed where Mr. Pata began to headbutt Mr. Jones. According to Mr. Howell, he and Mr. Monker broke up the fight, allowing Mr. Jones to get away and leave the room. Mr. Howell testified that as Mr. Jones left the room, he said, "Might as well call your Zos and clip up," which Mr. Howell understood as a reference to Pata's Haitian friends. Mr. Howell also testified to an alleged altercation between himself and Mr. Jones in Patricia Dunac's dorm room in the fall of 2004. Mr. Howell claimed that he and Mr. Jones were playfully slapboxing in Patricia Dunac's dorm room. According to Mr. Howell, after he got the best of Mr. Jones, I wonder if that's really true. Like, did Mr. Howell win this slap box? They say that Mr. Jones left Miss Dunak's room and returned minutes later with a short-barreled revolver-style firearm that he pointed at Mr. Howell. This is what's so unbelievable. When we were listening to this, I was questioning if the story is that only Mr. Jones is leaving and they're all in this dorm room, which dorm rooms are not that big. All three of them are there in this dorm room. Jones leaves and comes back in. And somehow what he's about to do next is something that only Howell sees and observes and swears that Patricia wouldn't even have seen or been aware of. But there's no indication that Trisha leaves the room, or there's a reason why if she's in this tiny dorm room, she wouldn't see this happen. So he says Mr. Jones then put the fire. He comes back later. He walks back in the room minutes later with a short-barreled revolver-style firearm that he pointed at Mr. Howell. According to Mr. Howell, Mr. Jones then put the firearm away and said he was just playing around. Mr. Howell stated that he had never seen a firearm in person prior to this alleged incident and did not know the make and model of the firearm he claims was pointed at him. However, he claims, and he doesn't say he pointed at his face unless they're not getting that detail. Remember, the state was representing that the claim was he pointed it at my face, and I didn't remember hearing that, and they're not quoting that here. Maybe they're strategically leaving that out, but it just says at him. So then they say Mr. Howell stated that he had never seen a firearm in person prior to this alleged incident and did not know the make and model of the firearm he claims was pointed at him. However, he claims to have recognized the revolver style from watching Westerns. Further, Mr. Howell stated that Miss Dunak was in her dorm room when this happened, but neither saw nor heard any part of this. Yes. Oh, because she was straightening up her room and not paying attention. Moreover, come on, your room is cleaned up before you have people come over. So then he says, although Mr. Howell stated that he was frightened, he conceded that he did not tell anyone that this had occurred, other than Mr. Pata. And then what does he do? What did we hear that he did? He doesn't report this. He doesn't go to university personnel or coaches, or any of the multiple detectives who interviewed him following Mr. Pata's murder. The first time that this alleged incident was disclosed was when Mr. Howell provided a sworn statement to the police in 2021. Oh, they leave this detail out. He leaves Trisha and Jones behind. He ends up leaving. So this just happened. And he leaves this dangerous person who just pulled a gun with this girl. And they don't put that in this detail, but we heard that we watched the testimony in session 1. So finally, Mr. Howell testified to a locker room fight in the late 2005. According to Mr. Howell, he approached Mr. Jones to confront him about comments allegedly made to his girlfriend. Mr. Howell admitted to punching Mr. Jones when he was not satisfied with his response. Following this altercation, Mr. Howell testified that he saw Mr. Jones make a call as he left the area. Why would you punch somebody that tried to pull a gun on you previously? After playfully slap boxing. Why would you confront someone adversarially? Maybe you thought because it was a locker room it was different. But if you were really scared of somebody, would you just walk up and punch them in front of a locker room full of people and think that they're not going to come get their get back? If you already had this dorm altercation where you're saying you better get your clips and call the Zos, like, this is not, it's not computing. Yeah, Pashan. I was terrified for my life, so I went to get takeout without a word to anyone. I don't know. Oh, man. Yeah, the sus face is a good one for this one. So, they have this altercation in the locker room. Mr. Howell testified that he saw Mr. Jones make a call as he left the area and sent an unknown person to eavesdrop on this phone call. According to Mr. Howell, this unknown person reported to him that she heard Mr. Jones say something to the effect of, "They tried me, clip up." Mr. Howell advised that he was familiar with the phrase clip up from music and common knowledge. Yeah, and so we're still saying unknown person. So the state hasn't identified who this person's supposed to be, even though Mr. Howell says it was like an athlete that he knew at the school. So apparently he doesn't know that person well enough to give the state a name. Edwin Pata. The state then called Edwin Pata Bryan's brother, who testified that in the summer of 2006, he and Bryan were at their mother's apartment catching up when Bryan mentioned that Rashaun had threatened to burn him in the head. According to Edwin, both he and Bryan understood that to mean shoot him in the head. Edwin testified he advised Bryan to tell a coach. However, Bryan said there was no need and later confirmed he did not report it. Edwin did not report this to police, coaches, or either. And to be, I mean, he was saying like, how would I go in and like go to the coaches and say all this? Like, that part makes sense to me. Like, he's not on campus to tell somebody. Edwin testified that Bryan did not take the threat seriously and had a tendency to brush off such things, although Edwin also described Bryan as concerned based on the fact that he brought this up to Edwin. Edwin associated the threat with ongoing issues, including a dispute over a handicap parking decal. But he did not know precisely when the threat was made, only that he believed it was recent. Beyond the alleged threat he recounted, Edwin stated that he was not aware of any other threats allegedly made by Rashaun to Bryan. Edwin believed that he had told Detective Dominguez about the threat before the statement in 2021, but he could not recall when he first raised Rashaun's name. So all of these statements are coming in after it would be well known, like this idea of, oh, he said he'd burn him in the head. Well, you never said this to anybody real time. You've had time to think about this incident. You've probably heard multiple times that that is the way his death was inflicted, that he was shot in the back of the head, execution style. And now you can, maybe you didn't really hear this in the moment. Maybe this memory's new, if it's a real memory. But it's not something that can't be explained by future information. And to me, it's starting to not pass the smell test that nobody said anything until 15 years later. When we really want somebody arrested, we want somebody else held accountable for the death of Bryan. And mom's still upset, mom's crying. Mom could be going to other family members who are raising eyebrows trying to figure out who did this. So we really need to make sure that police get somebody and arrest somebody and there's closure here. Because we don't want other people around us raising eyebrows still trying to wonder out who's sus. Right? I don't know. I think the more I read this, the more I'm curious about the family members suddenly all having this statement in unison together, the three of them. And I really don't like to disrespect family members and what they might be going through to try to get justice for their kids. But I think it's a very odd thing that they all figure this out around 2020 when they're trying to get ESPN and the police to put some pep in their step after 15 years. So I don't know. But yeah, so they go on here to reiterate here that Edwin testified that although he offered multiple leads to the police on the night of the homicide, Rashaun's name did not come to mind. So contemporaneously, he's volunteering people, but he doesn't think of Rashaun. According to Detective Dominguez, Edwin never mentioned any threats by Rashaun to Bryan, while Dominguez was the lead detective on this case between the night of the homicide and August of 2020. Because August of 2020 is when we handed over to Segovia, to the guy who makes a social media account and apparently has a burner account talking about this case. Then we've got Fenel Pierre. The state also called Fenel Pierre, a nice short paragraph here, Bryan's brother, who testified that in October of 2006, Bryan told Fenel that Rashaun said he would bury him in his draft suit. On cross-examination, Fenel conceded that this alleged threat was disclosed for the very first time during his deposition on June 12, 2025. 19 years later. While Fenel claims that he told Detective Dominguez that Bryan had issues with Rashaun on November 7th, 2006, when Detective Dominguez was asked whether Rashaun's name was raised to him by Fenel on the night of the murder, the detective stated it was not. If this is referring to testimony on the same day, I didn't see a clip of Detective Dominguez's testimony. So then we've got Detective Juan Segovia. And this wasn't included either. That sucks. Finally, the state called Detective Juan Segovia. The detective assigned, let me just Let me go to YouTube real quick and double check that. If I search local 10. Oh. Yeah, I only see his testimony at trial coming up, not pre-trial. That sucks. Yeah, I don't see anything pre-trial. Definitely balls. So we're stuck with what we'll see him testify to at when we watch the trial from February. But yeah, so they say they call him at this hearing that we watched in session 1. The detective assigned as lead on August 25th, 2020 to testify about his interrogation of Mr. Jones on August 19th, 2021, the day of his arrest. Detective Segovia affirmed that Mr. Jones maintained his innocence throughout the questioning, denied owning a firearm in college, and stated that he had nothing to do with Mr. Pata's homicide. Detective Segovia also stated that the medical examiner removed a damaged .38 caliber bullet from Mr. Pata's head during the autopsy. Was someone present for the autopsy? I guess maybe he's just relaying from the report. And then Detective Miguel Dominguez. So we didn't get to see that either. They called him. The defense called Detective Miguel Dominguez as a witness in its case in chief. Detective Dominguez was the lead detective assigned to Bryan Pata homicide investigation between November 7th, 2006 and August of 2021. And he responded to the scene on the night of the murder and was responsible for the investigation of the case for almost 15 years. At the hearing, Detective Dominguez confirmed that the murder weapon was never recovered, the type of firearm used is unknown, and the only physical evidence on the scene was the bullet removed from Bryan Pata's head during the autopsy. Now, this is relevant to the argument, again, that if you're trying to prove a pattern or particularity or specificity for this Williams rule evidence, but we don't have any of this stuff, well, then statements that somebody might have had a revolver wouldn't even line up because we don't actually have that fact established. We don't have that fact on this is what we know about the crime scene side of this case. So it's important to get that on the record. According to Detective Dominguez, no one saw the shooting or heard the shooter make any threats to Mr. Pata before he was shot. Detective Dominguez conceded that practically nothing is known about the circumstances surrounding the murder. And then they're going to go through the issues. So whether the state proposed 4042 evidence, like the dorm room gun allegation, they're calling it the 2004 or 2005 clip-up dorm room fight. The 2006 threat statements relayed by Bryan's brothers is inadmissible because it does not go to any material fact genuinely in dispute and instead functions as impermissible propensity evidence. Then we've got whether the state failed to prove the collateral acts by clear and convincing evidence, and whether much of the proffered testimony is inadmissible hearsay not fitting any exception. 3, whether, even assuming marginal evidence, 4042 evidence must be excluded under 403 because its unfair prejudice, confusion, and feature of the trial risk substantially outweighs any probative value. So then they go through the case law on this. So, in the interest of getting through this docket, we won't be reading the legal stuff, but again, they want their initial motion to strike this evidence. It can't come in. They're asking for it to be granted. Okay, and then let's see. How do we have another notice of intent to rely on evidence of crimes or wrongdoing on the 26th? We get more? So we get another notice of intent. 1, 2, 3, and 4. These are the same ones. What do they change here? Okay, so after the hearing, they have an additional act that they want to introduce. In 2006, Kareem Brown, a fellow University of Miami football player, heard Rashaun Jones state that he owned a .38 caliber firearm. This information was provided to Detective Segovia on October 15th, 2020. Kareem Brown was deposed on April 25th, 2025, where he testified under oath to this information. And then we've got the deposition. So while gun ownership is not a bad act for the purpose of Williams' rule, the state is seeking to introduce this evidence to show that the defendant did in fact own this caliber firearm and not just a gun in general. Well, dang, this is after the hearing on these issues that they're disclosing this. So then they've got a tiny piece here. Let's see. The deposition was April 25th, 2025. Did they disclose this deposition? Most recent message is June 12th, 2021 at 7:33. I said happy birthday and he said thank you. All right. Did you guys ever have any conversations or that are even remotely or tangentially related to Bryan Pata's murder? No. Okay, and the other question I asked was, has your sworn statement ever been taken in regards to this investigation? Sworn statement? Have you ever been asked to like sworn in? Like today? Like, no, I don't think so. All right, one moment, please. I want to briefly touch back upon the conversation with Detective Segovia. Do you recall the police officer that went to visit you at Central High School? Do you recall speaking to them at all? Statements that Rashaun made in college about carrying a .38? In regards to both, yes. Okay, and what do you recall of either those statements or of what you told the detective? In regards to both, I've heard Rashaun say that, he had a .38, and I've also heard people say Rashaun had a .38. Did you ever report that early, or are you just confusing these two things? Do you know when did you hear Rashaun say that? Back in college. Do you know when? Nope, in 2006. How do you say no and then give an answer? That's the exact answer you need to give. Okay, do you know roughly when you heard people say that Rashaun carried a .38? In 2006. 2006? Anything before then? No. One moment. Do you know Dwayne Hendricks? You're asking me? Yes. Yes. Okay, how close were you with Dwayne Hendricks? Teammate, he was younger. He played D-line with me. So we were in the same meeting rooms. Cool kid, that's about it. Do you know anything about his relationship with Bryan Pata? They were same thing. I mean, I can't speak on it. They were roommates, so I'm assuming they had to be close somewhat. And then that's all the deposition that's included here. So they add in this whole extra bullet point because of something that they should have been aware of, because that deposition's from April of 2025. By the time they're filing these motions in July and August and having a hearing that already passed. So we're getting more stuff. We're getting more stuff coming in late. Let's see. Notice of deposition. Do they want to depose Kareem? Okay, no, this just says Ed Hudak. I don't know that name yet. We've got to find out who that is. All right, let's see. We've got motion to disqualify. Aha. And this is the first motion to disqualify a judge. I do think we're going to have to do session 3 as documents, you guys, because this is a long one. I think there's some stuff in here that would make it shorter. But this is a long one. And I believe we might also want to listen to the plea colloquy, the plea hearing, where the judge seems to be telling Rashaun, you might really want to think about just taking this plea. Are you sure? I mean, what you're facing, you'd be coming out in a pine box if you take it to trial. So, and that's paraphrasing, but we'll actually hear her quotes when we listen to that. And that's like an hour long as well. So I do think we'll do part 3 as a continuation of this docket, because we are only in August and we've got to get a lot of it's just all of this stuff that's not, and these aren't all big things either. A lot of it's just getting costs paid for by the court. But we've got to get all the way to here before trial starts. So, yeah, about here. So, we are leaving off. Let's leave off at this motion to disqualify. We almost made it to 500. We almost made it to 500. That is where we will start tomorrow. We will learn more about the judge, what the defense thinks is the judge's shenanigans, why she should be disqualified, why if she remains on this case, Rashaun Jones will not get a fair trial. So session 3 will become the rest of this docket deep dive up to the trial. Session 4 will be the trial. We'll make both happen tomorrow. So Because this is 4.5 hours. This is approaching 4.5 hours already. So we'll definitely break this up. Yeah, Mel's like, all these new info tidbits. Listen. There's so much more. There's so much more that I don't think has even been as bad as like the little bit about Segovia and his burner accounts on social media. So I can't wait to go over all that. I know if, like in the trailer there's like a preview of it. But like why? Why in the world, if you're a lead detective on a case, are you sitting on social media with a burner account talking about the case? And I don't know what the information is that on Information and Belief it's supposed to be his account, but it's like got serious oomph behind it. Like it's a credible claim that this is a burner account that belongs to lead detective Segovia, and he's got this internal affairs investigation open on him now. Like, that's not good. That doesn't look good. And maybe they'll find out that it isn't really him. Oh man. So we're gonna get together. We're gonna have 2 sessions tomorrow, I think. And again, even though this hearing's supposed to take place on Monday, because of the way that this court, when they're allowing cameras, they're still not allowing live streaming. It would be something later in the day we'd get back together and on Monday and see what happened after it's already done. So if necessary, we could probably do something Monday morning on this case. Keep catching up, deep dive on whatever, who knows. I do think tomorrow we will continue with this. Like leaving off on 498. I saw Amy in the building. Good to see you, Amy. Hope you're doing well. We've got... Please do more body cam uploads on your channel. I keep checking for uploads on your channel. Unless you got tired of doing it. I won't push you into doing something you don't want to do. But love the work you put into that over there. Now, when I say tomorrow, no midnight stream, because I did a lot of reading here, and I don't want to start watching the trial until we get through all of the pretrial motions. So, we're going to get through all the February motions, and then we'll watch the trial. I think that's the right way to do it. So, probably tomorrow morning we'll start at like 10 Eastern. Yeah, I'm trying to run out of here. I'm trying to run like Dave Howell, his short little first interview that he did. So thank you so much, guys. I'm, good to see your thoughts. And I'm open-minded to it, right? Like if we get through some of these motions, if we see in the trial, because I didn't see everything in the trial. I saw select witnesses. I saw one of his brothers testify. I saw a few of the officers, but I don't remember Segovia. If we see something at the trial that's like, I don't know how you overcome that, I'll let you know that I think it's damning. I'll let you know that I think it's really bad. But so far, the danger zone is just the fact that he's accused and charged at all, right? That's extremely tough, right? The idea that if we're here at a trial, there must be a reason why we're here. We should hope that prosecutors wouldn't bring garbage to trial. So even though I think it's a sucky premise to start off on for the accused, for the defendant, at the same time, it's something that I think would be a noble thing for prosecutors to always achieve when they bring a case, but that's not always the case. So the fact that he's on trial at all is already a huge thing to overcome, even though he's supposed to have the benefit, the presumption of innocence, until the case proves their case, and that cloak of innocence is removed. I just don't think psychologically that's always how every person looks at a case. Additionally, if any of this prior character evidence comes in and people don't think about it, don't process it, it can sound really damning that somebody is walking around all willy-nilly saying he's going to burn you in your draft suit and you better get your clips, always fighting with people. Especially if the attorneys don't clarify it. The attorneys were very sharp with their questions during the pretrial hearings that we watched. Well, it was Bryan that punched Rashaun in the face. It was Bryan that had him on the bed. It was Bryan that headbutted him. When an attorney can get stuff like that, it can undo the damage of how the story sounds on direct. Oh, they got into a fight, and it just sounds like, oh, it was mutual, or Rashaun Jones was the aggressor. But the attorneys did do a great job, I think, of clearing up those details and making it seem like Rashaun Jones is the one who's always getting beat up on, but being the cool one about it and just wanting to leave. which is a great look for the defendant. But you've got to overcome the initial prejudicial impact of the story. So, yep, 10 o'clock tomorrow. We'll do 10 o'clock in the morning for session 3. And we'll probably put like an hour break in between whenever we end that and come back for watching the trial. So, don't skip sleep. Don't skip sleep. So, the sun has already risen. Cool to think about. I always love that people are ahead of time. You're in the future. All right, you guys, everybody have a good night. Thank you for tuning in. Thank you for sharing your thoughts. Thank you for taking the deep dive with me. And I'll see you guys today for some of you, like Psychodynamic. See you tomorrow for a lot of us. Bye, guys.